My senior to make the mention first, my lord. In fact, in item 8, my lord, my additional affidavit is ready. I'll place it on record by tomorrow. Lordship will kindly take on Tuesday. My lord. Tuesday, my lord. Yes. On Tuesday, my lord. Kindly. Deeply obliged.
May I please? One item, this is item number 2 of today's daily fees. It has been wrongly shown in the motion column here. It should come in the hearing column here.
It should come in the hearing.
So because the case is ready already. Lower court record is also there.
Let the matter.
Both parties are here.
Let the matter reach, we'll pass the order.
Yes. In the next week, it may be giving your order. It's a maintenance matter.
Let the matter reach, we'll pass the order.
Yes, it should be listed in the hearing column here, no?
APC Lordship. My lord, I want to Lordship indulgence to reach the matter in the any day of the next week, my lord. My lord, matter is to admittedly seniority, but some new development is going on in the school, my lord. My lord, dispute turning to be my lord personal rivalry, my lord. So my lord, matter needs to be some
19th.
My lord.
Yes. In a sort of item number 30, the hearing column, I am on behalf of the advocate concerned. He is not indisposed of. Maybe possible for the day only.
You are praying on whose behalf?
Talukdar, my lord.
May I please? My lord, item 40 and 41, my lord. Can it be taken at 2, my lord? Some urgency is there. Since 2021, we are not getting this salary because of some interim order passed by the Honorable Court.
Inform the other side, Mr. Mun.
I will inform, my lord. Obliged.
My lord, I beg to mention item number 12, my lord, on behalf of A data, my lord. He has some difficulty, my lord. Next week, any date, my lord, only for today.
May I please, your lordship? For item 35, day before yesterday, it was listed and your lordship had directed us to produce the records. Lordship, records today morning we have received. So sometime may kindly be granted to us for going through the records, lordship. Next week, any day, lordship may fix. We have taken the consent of the other side also.
These are admission matters.
Lordship.
Let the matter reach, we'll pass the order.
Lordship.
There are 3 matters, criminal revision petition made come on Monday for orders column, 21 matters.
17.
17.
Yes, Mr.
May I please, your lordship? My lord, I beg to mention a series item, my lord, from 21 to 24, my lord. Thank you. Lord, I had some personal difficulty today, my lord. Can it be taken up on next week, any date, my lord?
With regard to your matter, and you are involved in all the matters.
My lord, I am involved in all the matters, my lord, and senior counsel, Mr. Dedas is also.
My lord, he has also come personal difficulty. They have informed us yesterday, my lord. So let it be after days, my lord, after a week.
Of October. As agreed with you. Only pay of the council for the party. List on 24th of October. No further agreement will be given to the petitioner. Either of the parties. As the matter is of 2014, 2019, 2020. Next.
Smile. Milord, I filed an IA, yesterday, Milord. The matter may come up tomorrow, Milord. It's regarding selection and appointment of the Milord professor in KK Hendrik State Open University. Milord, as per the division bench judgment, hearing proceeding was going on. But since Milord stay order has been Milord granted by the Honorable Single Judge, without intimating Milord the Standing Council of KK Hendrik. So, Milord, there is an urgency. Mr. K. N. Chaudhary will lead me in this case, Milord. Some Milord external experts from Delhi and Milord.
When is the date fixed?
Milord, after 4 weeks, Milord. Since all are Milord waiting, Milord, and they are from external Milord domain expert, Milord.
17.
Milord.
17.
Can it be tomorrow, my lord?
Why?
My lord, since my lord, the proceeding is,
When is going to happen? That's why. When did you fix the interview?
my lord, interview was on 9th, my lord, last, my lord. So
Then?
everyone is waiting for this, my lord, proceeding, my lord, as per the division bench judgment. So, my lord, I will satisfy your lordship, my lord. At least
Tomorrow not
tomorrow, my lord,
possible.
we'll have a try. my
No,
lord.
already more than 45 matters are there. No, we are not heading up to that.
We'll have a try, my lord, at least if time permits.
17. 17 is a, we have a lesser cases. As of now, only 8 cases are there. So it will be better.
My lord.
Yes.
Email is noisy.
Yes, yes.
Can it be on 16th, my lord?
Monday not possible. Motion they don't make.
Most obliged.
If pending case, my lord, made a criminal petition, my lord. It may be taken on next week, any date, my lord. It was listed, my lord, last, my lord, 24/1, my lord.
2020.
My lord, I beg to mention a repetition, my lord, on next week, my lord, for orders, my lord. This is regarding appointment of assistant professor, my lord. For orders,
23rd.
my lord.
Item number 19.
19.
Lordship, the part head matter, Lordship, urgency, the person is behind the bar, Lordship. If possible, Lordship, 2 as the first item, Lordship, at 2 p.m.
We'll consider.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of one WPC matter, Your Lordship, next week.
We'll start on 23rd.
Obliged.
Lordship, on the joint prayer, Lordship, I beg to mention item number 9. This matter may be taken after 2 weeks, Lordship.
Why after 2 weeks? After 2 weeks, the vacation will start.
After a week, your lordship.
26th. On
May
26th.
please, Your Lordship,
Obliged.
listing one repetition for admission. Any date, Lordship,
24th.
Lordship, 23rd or 26th, any?
Okay, on 23rd.
Hey, please, Lordship, I beg to mention item number 29, my lord. Maybe after 1 week. 29, my lord.
Have we informed the other side?
Yes, my lord. After a week.
Yes.
Obliged.
May I please, Your Lordship, I am paying for listing of a matter, Lordship, for orders for Monday, Lordship.
Tuesday, 17th.
Lordship, I beg to mention for listing of a matter on the compensated ground. The DLC meeting will be held on the 18th of this month. So, Lordship, they want the order from this court or the case may be disposed of. Otherwise, our application will not be considered. So,
16th.
Lordship, I beg to mention a criminal petition, revision petition, next week, any day.
17th.
Mid-please, Your Lordship. My lord, I pray for listing of a criminal revision petition. A NBW has been issued against the petitioner who is the executive director of a company.
Fixing the date when?
My lord,
Fixing the date when?
the lower court,
Next date, yes.
my lord, lower court date is there, but the NBW has been issued. It is for
When the-
execution.
When is the next date?
Next date is, my lord, somewhere in October.
When did
But-
the order was passed?
It was passed on 21/8. We filed it on Monday, my lord. And on the ground, my lord, we also attempted to file a recall application before the magistrate. He has refused it, my lord. My lord, can we do it tomorrow, my lord? Because the police has approached the bungalow, my lord.
16th.
16. Then, my lord, let it be Tuesday, my lord.
17th.
Good.
May it please, Your Lordship. Lordship, this is in regard to item number 10, Your Lordship. Also, with the consent of the other side, I am praying for adjournment of the matter for the day. Item number 10, Your Lordship.
2020 matters.
Yes, Your Lordship, my senior is not doing well this week, Your Lordship. So he is unable to appear.
Who is appearing?
Mr. J. Abedin, my lord.
Pleasure.
May please, Your Lordship, I beg to mention for listing IA in criminal revision, 392/2024 on 17th,
18th.
18th.
May I please, Your Lordship? Lordship, I beg to mention for listing one contempt petition matter, Lordship. Timely matter will be fixed next week, Lordship.
Okay, on 19th.
19.
My lord, relief
that was sought for, my lord, this has already been considered by the government. The applications for, my lord, promotion, my lord, were not accepted. And that is why the writ was filed, my lord. They have subsequently been taken on record, my lord, and therefore, my lord, the cause of action does not survive.
Learned counsel appearing for this petition. Who is in the, Mr. Sahil, candidate counsel clarification. To be appearing for all government college. That's it. So government college. Lots. 1, 2, 3. During, as during.
Consideration.
Petitioner got the relief to his restriction. Mr. Pathak, learned counsel appearing for the B Pathak. On instruction. If not pressing this petition. So who is the counsel for the respondents have no objection? According. The certification stands. That's the best. Okay.
Obliged.
In this matter, item number 2 should be segregated.
Any two is what different?
2 is different. And maintenance, but it should be come in a hearing column.
Yes, I
No,
have
these
heard
are
a
similar
respondent.
matters. You can-
In respect to item number 2.
Yes, these are, I think, similar matters where remand is required.
In case of my case, remand is not required actually. There is no merit of the revision. It is second revision they are doing.
ऐसा तो नहीं, राजनेस नहीं है। क्यों?
The dates may be fixed, Lord, in respect to item number 2.
कोई दिया। But then, यहाँ तो कुछ circulate होता है, यहाँ तो कुछ course है। हमने principal judge, हाँ। To examine assessment liability, people are, they will decide on the name. Oh, increase also.
Hello.
अपने पढ़ाई भी करते हैं, ये तो follow करते हैं। तुम्हारे कैसे कैसे लगे तो डिजाइन हाँ दिया तो हाँ ये है इसमें दिया तो तो हमें हेरी ब्रो चाहिए सके मुझे वो जुडिशियल मैजिस्ट्रेट के होने फैमिली कोर्ट ऑफ सके नो
That's the order. Under section 125, towards maintenance. In favor of the sole respondent. Or the suit.
advocate for
But allow the principal thus communicate. Come to the happy. By judgment. Dated judgment in order to the 26. this matter be segregated from the other connected methods. Two thousand eighteen, much prior to the judgment of the Honorable Supreme Court in the case of Rajneesh versus Meghalaya. Decided to be 11 to
Are we non versus permitter or seven?
this matter.
Bombay High Court said it was such a
Place this matter for hearing on 22/10/2020. As
22/9, no,
10.
22/10.
This is only with regard to item 2, not for others.
Oh, acha.
Yes. For the others, only for number 2.
And for others, Lordship, as we had already submitted, Rajneesh Neha, that is although under 142, that needs to be followed. And then there are recirculation directions are there. Then there are so many high court judgments where the case was remanded to the family court or the respective courts to follow it and pass orders. So my humble submission would be let the cases be remanded back and let them follow Rajneesh Neha, get the affidavits on asset and liability and then pass orders. In few cases, it might increase also.
Lordship, then specific time frame should be required, Lordship. Otherwise, parties are suffering, Lordship. Basically, who is seeking maintenance, Lordship?
Yes, for the petitioners.
My lord, in item number 4, my lord, I am before your lordship because the 125 proceeding has already been disposed of. Against that, we file a revision, my lord, and revisional court also avail the lower trial court judgment, my lord. And in entire 2 proceedings below, my lord, assets and liability affidavit never been called for.
But that was an order passed after the judgment of Rajneesh and Neha.
Yes, after this.
So that is why.
Yes, my lord.
And
So-
this is a criminal, this is again criminal revision. Anyway, we'll
Yes.
pass the necessary order.
Yes, my lord. In my case, my lord, there is no affidavit has been called for by either of the 2 forums, my lord. That
Yes,
is one
Lordship,
case.
the court doesn't call. Lordship, day before yesterday, I had a case here in the family court, Kamrup Metro, Lordship. And this is maintenance case. When I was asking, no, that means not to the judge, the court master who is actually looking after all the cases at that time. They say, no, amar yate to time meheri no hoy." They are simply telling like this, Lordship.
And another, my lord, may I submit, my lord? Another point, my lord, maybe of importance, my lord. Para 72.6 of the judgment, my lord. That is para 72.6. Wherein it is stated, my lord, that when the parties discloses or not discloses the specific informations, there is a, my lord, provision, my lord, to take up a proceeding under section 340 of the CRPC.
Which Rajneesh Neha?
Yes,
Metra
Rajesh,
for?
72.6.
Oh, yes, yes.
May I read, my lord, the para? If there is any dispute with respect to the declaration made in the affidavit of disclosure, the aggrieved party may seek permission of the court to serve interrogatories and seek production of relevant documents from the opposite party under Order 11 CPC. On filing of the affidavit, the court may invoke the provisions of Order 10 CPC or Section 165 of Evidence Act if it considers necessary to do so. The income of one party is often not within the knowledge of the other spouse. The court may invoke Section 106 of the Evidence Act of 1872 if necessary, since the income, assets, and liabilities of the spouses are within the personal knowledge of the party concerned. Then, my lord, 72.8 paragraph down below. The pleadings made in the applications for maintenance and replies filed should be responsible pleadings. If false statements and misrepresentations are made, the court may consider initiation of proceeding under Section 343 CRPC. So that is the one important aspect, not because we have come across that because the either of the spouse, my lord, doesn't disclose anything or discloses false information, my lord. And even if, my lord, I have come across, even if the court below, trial court, learned trial court is being pointed out regarding this aspect of this judgment, my lord, nothing was done, my lord. That's my humble submission, man.
I think four Lord. Last time I pointed out, Lord, that the price was come to a conclusion that the provision has sufficient means. Was examined that the school, that the tea garden, so based on that, the material was.
But that is not through the affidavit and assessment liability affidavit.
Because
That
in
is not through
these,
that.
according to the guidelines, they have to give 3 years
Yes.
bank statements, all income tax returns. So those things, we make things clear.
And also, my lord may just point out one more thing, my lord. Then in the format given, my lord, enclosure 1, 2, and 3, there's a specific para, my lord, in every affidavit. Para 3, in declaration, my lord. May I read, my lord? I understand that any false statement in this affidavit, apart from being contempt of court, may also constitute an offense under section 199. We read with section 191, 193 of the Indian Penal Code, punishable with imprisonment up to 7 years and fine. And section 209 of the Indian Penal Code, punishable with imprisonment up to 2 years and
In the
fine.
declaration or in the?
Yes, it's a declaration, my lord.
In the enclosure 3 or which one?
In every enclosure, my lord, 1, 2, and 3, para, in declaration number 3, my lord. There are 3 enclosures and declaration is also there, my lord. So this is, my lord, very important thing, my lord.
In my case, you know, I can number 6. Yes, Mr. Fukan, just coming to, come back. Yes. Anyone to submit, will come back. Anyone from the petitioner you want to submit?
Lord, I am for the petitioner, my lord. My lord, as my respected senior friend has already submitted, my lord, this is a law and the trial courts below are duty bound to follow the prescription of the law. Now, my lord, in most of the cases, my lord, we have seen that, my lord, although there is a circulation has been made by our High Court also, but it has not been followed, my lord. So exactly in this bunch of petitions, my lord, same thing is there, my lord. So my lord can remand it back the matter for fresh adjudication.
Fresh adjudication, lordship, call for because other things had already been adjudicated, lordship. Apart from that means the court will call for the affidavit, lordship. Both the parties have to submit and with a definite time frame, lordship, this has to be disposed, lordship.
What we will do? Ultimately, since both the parties are before the court,
Lordship.
will give a respective dates
Yes, lordship.
before to appear.
Appear.
And if whether it is family court or whatever the court, within a time frame, we'll ask them to submit the affidavits of liability. And thereafter to decide, right?
Yeah.
And then what we will also do that within a period of say 2 months or 3 months.
Lordship. Lordship, one more prayer, lordship, interim whatever has been granted, lordship. This is the minimum amount, lordship. This may kindly be paid, lordship. In my case, preparing lordship, now they have stopped paying anything, lordship. Only 24,000 till date has been paid, lordship. Is defying all the court's order.
We considered your submission because you made it clear very specific. You have also filed an IA.
Yes, lordship.
Otherwise, the agreed person will be in a destitute condition, right? We have considered that aspect too.
But in
it
Raj,
is found
But my lord, in the
order of the family court or the appropriate court is not in conformity with the law.
Yes.
my lord.
In that case, that is why we will giving a lesser time.
No, my
so
lord.
that the- so that the family court or the concerned court can pass the order. And since you are all representing both either this side or that side and aware of the fact, so we will be directing the concerned court to give within a period of 10 or 7 days to file there. Will not want to give the long date for submission of that.
Yes, lordship.
Because now by this date you are fully aware. When the matter will go back to the concerned court, only the necessary order will be passed for submission of the affidavit and the liability. So you have to, on both sides, you have to make yourself ready. So whatever the order, will also make it clear that since this order has been passed in presence of the respective council, so for filing of such assets and liabilities affidavit, shorter date should be. It not be long date for 3 months or 2 months. We'll make it clear in that.
as far as interim is concerned, even interim, Rajesh Neha said to consider.
Even for the interim that have the assets and
Yes,
liabilities
yes,
has to be filed. So whatever Ms. Patate has submitted, but thing is this we consider. Thing is, in that case, since the order is not in conformity to the direction passed by the Honorable Apex Court, we cannot accept that.
Yes.
That's the reason. Whatever the amount that has been
Lordship.
assessed and interim maintenance, that also. not
It may
only after
increase and
such-
decrease also, my lord.
Increase it when it
This
is
is
so high.
pendenti light, Lordship. This is pendenti light.
No, pendenti light, no, pendenti light.
The interim Lordship that has been, this is pendenti light.
No,
Lordship.
in our case, my lord, the divorce proceeding is already over. So therefore, there is no question of pendenti light maintenance at this moment, my lord. Only one.
Look into that.
My lord.
That
Only
remanding
125
Bombay
is
High
there.
Court judgment, Lordship can see once. It is only a persuasive value. That Bombay High Court judgment of Pranita versus, yes, Aditi.
Just give us the citation.
This is Nayan versus Pranita. This is citation I'm giving from Supreme today. This is 2021 Supreme Bombay 583.
There it is.
There, the last paragraph, the Bombay High Court has directed them to finish the proceeding within
Today,
6
right?
months.
Nayan
Yes.
versus Sunita.
Nayan versus Pranita.
Oh.
Nayan versus Pranita, 21 Supreme Bombay 583.
2021 Supreme.
21-0, they write 0. Supreme, then within bracket Bombay 583. I can read out the relevant part. That is paragraph 28.
Sunita versus.
Nayan versus Pranita.
Okay.
Nayan versus Pranita.
Yes, what is the observation made by the?
This is observation is within 6 months they the matter is remanded back to the family court. I'll just read out paragraph 28. It's the last paragraph. Though the family court has held that Nayan is able to maintain Pranita and he has neglected and refused to maintain her, maintenance was denied to Pranita. Family court took into consideration some certificates, government labor officer, which states that Pranita is doing her work. She is working and she is earning 12,000 per month in her care, in cash. Pranita in her cross-examination has denied the fact that she was working. Family court took into consideration the photograph placed on record wherein Pranita was seen along with some other person wearing apparel of medical profession. The family court was of the view that prima facie the said photographs appears to be taken in the laboratory. Family court therefore held that Pranita in evidence has failed to disclose the fact that she was working and earning. It was also held that Pranita has suppressed material facts about her earning from the court and therefore come to the conclusion that Pranita is able to maintain herself. According to us, family court has taken into consideration inadmissible evidence while denying maintenance to Pranita. According to us, the family court has erred in coming into conclusion that there was no honesty in conduct of Pranita and all. Lordship can skip that part. In paragraph 99, it is held that affidavit of disclosure of asset and liabilities, Lordship, little before that, we deem it appropriate to rely on the ratio of the Honorable Supreme Court in Rajneesh and Neha, where guidelines is to be followed in maintenance matters. In paragraph 19, it is held that so and so. Then it shall be filled up by both the parties in maintenance proceeding, including pending proceeding before family court, district court, magistrate court, etc., as the case may be, throughout the country. According to us, the material on record does not justify denial of maintenance to Pranita, and we do not agree with the reason given by the family court while rejecting maintenance. We are therefore of the considered view that impugned judgment by the family court is unsustainable in faction of the present case and therefore needs to be set aside, and the matter is liable to be remanded back to the family court for taking decision on the prayer of grant of maintenance afresh by giving opportunity to both the parties to lead evidence according with the guidelines of Honorable Supreme Court in Rajneesh versus Neha. We answer this point accordingly. Then time frame is given. The family court shall decide the proceeding as expeditiously as possible. And in any case, within a period of 6 months from the date of receipt of order, the court should dispose of the matter. The parties shall cooperate for the decision within stipulated time.
We'll make it lesser.
Huh. This is, they are talking of the entire case.
One point of view, the opposite party, in my case, the matter was filed on 2018, there are onwards I have not got any detail. I may here on view that the opposite party, that is husband, may fear that I may unemployed you. In that case, Lordship in this matter, there is no any obligation that in assets and liabilities, whatever he is produced before the honorable court, in that relevant point of time, the court has maybe, it will be decreased my maintenance. Because I have filed a case in the session court challenging the order. Thereafter, it is been increased to 2,000 to 5,000. Now, after this court will remand back to the court here, okay? There is a hypothetical view that the husband may tell that I am an unemployed. In that part of that point of issue, your lordship may observe on.
There are other judgments. There are other judgments. In a particular case, if you have seen in Honorable Apex Court, it is the duty of the husband to maintain his wife.
Yes.
Even he is jobless, he have to
Yes.
work hard and he has to maintain his.
Yes,
There are
Lord.
judgments.
That-
Right.
That is my only.
Those things-
That is my part of, my fear
Probably
of.
the family court need not be informed of all these judgments. They are relating to these only, right? Anyway, look into it, Mr. Paul. Your submission, yes. Now they might have an assets and liabilities and affidavit saying that they are incomeless or they doesn't have any property. What will happen in that circumstance?
That may be observed.
Lordship, I beg to point out one thing, your lordship, in my case, item number 1, there was affidavit of assets and liabilities filed, your lordship, but in the judgment, there is no consideration,
Did not discuss.
did not discuss at all.
Well, one quick point, my lord, regarding the submission made by Ms. Bhattacharya, my lord, that during the time frame, my lord, these are specific guidelines given at para 72.3. What timelines should be, my lord, adopted? If I may read, my lord, the respondent must submit the reply along with the affidavit of disclosure with a maximum period of 4 weeks. The courts may not grant more than 2 opportunities for submission of the affidavit of disclosure of assets and liabilities to the respondent. If the respondent delays in filing the reply with the affidavit and seeks more than 2 adjournments for this purpose, the court may consider exercising the power to strike off the defense. So this is there, my lord.
See, basically, the time frame has been already been specified by the Honorable Apex Court.
Yes.
But in the case of the item number 1, it was already there, but not
Not
considered. when
disclosed,
issued.
not discussed, yes.
So these things will be different case to case.
It may be different, it may differ, my
We'll
lord.
look into it.
Always.
My lord, in this item 6, as my learned friend has submitted, it is, my lord, in the initial stage, DB case that was, my lord, dismissed by the learned JMFC, Amingau. Thereafter, they gone to the, my lord, appellate.
Your
court. Item 6.
My case.
Just my learned friend has submitted. So in appellate court, that is, my lord, by order dated 27/7/23, it was straightway, my lord, the maintenance is increased to 5,000. But earlier one, the main DB case was dismissed. So in this case, my lord, no affidavit on assets and liabilities was filed, neither, my lord, before the DB court or in the appellate court. And my position is that I am an unemployed husband, my lord, so this matter may be.
That's why you have said just now.
Well,
The others has been the
yes.
Apex Court. You have to maintain your wife. You cannot
Yes, sir.
just escape like this.
No, I'm not asking.
You may be saying that you
Yes.
cannot have a job. How many
Yes.
people have a job nowadays,
Yes.
right? But you have to maintain.
In counter, your lordship, now I am in psychiatric patient. Due to atrocity of my.
No, that is disputed fact, and it is a story. It is a story.
I'm deeply obliged.
Item number 1. In item number 1, who is appearing for the respondents? You are
My lord,
appearing, Mr.
notice
Dev,
was
you are
not-
for the petitioner.
Notice was not issued, your lordship.
Okay. For the petitioner. Number 3. Number 3, who is appearing? What's your good name?
M. Alam, lordship.
M. Alam.
Lordship.
You are there for the respondent. You are Mr. Number 4. Chakraborty, you are appearing.
Yes.
And who is for the respondent?
I'm for the respondent, R2, AW Amar.
5. Mr. Bhuyan, you are appearing.
Yes, Lord.
Lord,
And,
I am for the petitioner and my senior friend.
I am appearing on behalf of the private respondent, lordship, wife.
And in 6, who is appearing?
I'm respondent, I'm for the white. I'm for white.
You are Mr. Das.
Yes, he does. Well, in this case, a small submission is that main appellate order I have challenged through revision, that is
a delay was there and the IA is pending. So that item is not here, my lord, listed today, but this is only.
I is there. What is the
Yes.
number? Can you give us the number?
IA criminal 41424. That is main appellate order is challenged.
Give the number again.
IA criminal 41424.
Lordship, this is for limitation.
Yes, it is limitation because I have delay ground my file.
Respect on that point, Your Lordship.
Lordship,
No.
item 5, I had a IA, I filed one IA, Lordship. Lordship may kindly consider something on this, Lordship.
Definitely.
Deeply aware.
Problem.
To call for any.
Deeply aware.
Please put it. So that is very high. Yeah.
My lord, in this case, another case also filed, my lord. And the matter come along with it is, my lord, on 25th of this. One, my lord. Advertisement for an.
In the meantime, I will receive instruction, my lord. And latest, my lord, status of the case, my lord, both the cases. I read 33, this is a score.
In 33, my lord, I have not received any copy, my lord. Item number 33, my lord, I have not received any copy, my lord.
This is a score.
Mr. Mohanta, give him a copy. Which is the
Okay, my lord,
connected,
I'll serve copy, my lord.
which is the connected WBC?
Connecting WPC, my lord, this is 4653 of 2024. It is listed, my lord, 33 in supplementary, this, my lord. Number 3.
NCT.
First case. With similar prayer.
Similar prayer, my lord. Other group of student, first one, there was a 21 group of student, and next one is a 14 groups of student, my lord. In first one, NCT was not the party. In second one, the NCT made the party. Okay, yes, first one also, my lord.
Mr. Fukan, university did not file any affidavit.
We have already filed affidavit.
First one file, I have filed reply also, my lord, in first one.
In response to that reply, my lord, I will have to obtain instruction.
Because there was no approval regarding the, my lord, the meeting held to fix the cutoff mark. And I also challenge the committee constitution. There is also no approval, my lord. And as well, my lord,
Mr. Alam, have you received the reply of the university?
Affidavit, I have received it.
From the university reply you have received? Because you have to clarify.
But reply is not received.
His reply you have not. Heard Mr. P. Mohanta, counsel appearing for the petitioner. Petitioners.
I am for respondent 1 and 2, my lord. My friend.
And Mr. P.J. Fukan. Pending counsel Guwahati University for the respondent numbers 1 and 2. Also heard Mr. A. Alam, Standing Council NCTE, for the response number 3. Petitioners herein have challenged the cutoff mark set by the Guwahati University for counseling for admission in the B.Ed course of 2024-25 in each level, and it's in each B.Ed course. Fixing 90 as for unreserved category and 80 for the reserved category of candidates. Stating that the same is not in conformity with the provisions of the NCTE guidelines. The respondent university have already filed its affidavit, to which the petitioners have also filed their reply. Mr. Alam, counsel appearing for the respondent NCTE, submitted that he is yet to receive the reply of the petitioners to the affidavit of the respondent university. Copy of the affidavit in reply filed by the petitioners to the affidavit of the respondent Guwahati University shall be served on Mr. Alam, Standing Council NCTE. At least by tomorrow, obtaining necessary acknowledgement. The respondent NCT shall clarify its stand with regard to the stand of the Guwahati University, respondent Guwahati University, fixing the cutoff mark for counseling at 90 for general and 80. 90 marks. Yes, such affidavit when you will be able to file. Because
On 25th of my lord this month.
25th, when will you be able to file?
Within 2 weeks,
Within 2 weeks. The NCT shall file its affidavit on or before 26, oh my God, 27.
Friday, 27.
09 such and such without fail. List on 1st of October.
There is an interim order that should continue.
The interim order shall, or interim order passed earlier
On 27/8.
on 27/08/2024 until further order of before.
Well,
Next day.
Well.
Item number 33.
It was. 42.
Third, Mr. P. Mahanta, counsel for the Mr. P. Pukan, standing counsel for Guwahati University for expert numbers 1 and 2, and Mr. A. Alam, standing counsel in. Issue involved in this repetition is similar to that of the WPC number 4231/2024, listed as item number 7 today. issue notice.
Hello. Hello.
Returnable by
এটা পয়সা না কপি কপি পয়সা কপি না দেখো ফোন নাম্বার দিয়ে দিবেন
2 weeks. The respondents shall file their respective affidavits. In fact, no further affidavit is required. You have already filed your affidavit.
that is covered is same
The affidavit filed by the respondent university in connected WPC number 4231/2024. Will be the no further evidence that is actually involved in the filed by reply by the to which the petitioners of such and such already replied. The respondent number 3, NCT shall file its affidavit. Same.
must be
Applicant. The interim order passed earlier. The connected WPC number 4231/2024 on 27/08/2024 shall also be applicable in the present case. Okay. List along with WPC number 4231/2024 on such and such.
must be
Just a minute. The petitioner shall serve for such and such copy. Extra copies of this.
I'll
By tomorrow, obtaining necessary.
I'll serve
replacement,
today,
Mr.
maybe.
Mr. Yes. Sending out to Bombay University.
May it please your lordship. Lordship, the petitioner herein had applied for the post of registrar administration at the Tezpur University, your lordship. The advertisement contains the minimum educational qualifications and other desirable qualifications, your lordship. That your lordship will find at page number 18. The
Yes.
lordship, at page number 18 is the minimum qualification for the post of registrar administration at serial number 1. Being eligible, your lordship, I had applied for the post. Including the master's degree qualification of at least 55% marks, I have that, your lordship. And second condition that will be applicable in my case is 15 years of administrative experience, of which 8 years shall be as deputy registrar or an equivalent post. The third clause, your lordship. That is where I fall, your lordship. Accordingly, your lordship, I had applied.
Now, do you fulfill the criteria at number 2?
Yes, your lordship. Number 2, there are 3 criteria. I have to fulfill either one of them, your lordship.
No, please read. Kindly read 2.
At least 15 years of experience as assistant professor in the academic level 11 and above, or with 8 years of service in the academic level 12 and above, including as associate professor, along with experience in educational administration, or comparable experience in research establishment and or other institutions or higher education, or 15 years of administrative experience, of which 8 years shall be as deputy registrar or an equivalent post, your lord.
No, since you doesn't comply with you doesn't fulfill the last criteria.
I do, your lordship.
Which one? 15
This
years.
15 years of administrative experience, of which 8 years shall be as deputy registrar or an equivalent post. I have, your lordship.
You fulfill this criteria.
Yes, I have 28 years of administrative experience and about 9 years of experience in an administrative, in an equivalent post. Presently, I am serving as the finance and accounts officer of the Assam Science and Technology University, your lordship, since 2013. Presently, I am drawing salary at pay level 13. Herein, they say that at pay level 12 also. If your lordship kindly comes to the note below. Point
Please.
number 2, your lordship. For deputation, I'll read point number 1 also, your lordship.
The candidate will be appointed on direct recruitment or deputation basis for a tenure of 5 years or till attaining the age of superannuation, that is 62 years, whichever is earlier. Point number 2, Your Lordship, for deputation candidates holding analogous post or with 8 years experience at pay level 12 and having qualification and experience as indicated above shall be eligible. Lordship, in this regard, if I take Your Lordship to my application, that will make it clear that I have the qualification. Page number 22 onwards, my application starts. And page number 23, Your Lordship, is the last portion is my relevant work experience. Page number 23. Page number 23, the last is at the bottom side, Your Lordship, relevant work experience. Number 1, Your Lordship, is both administrative and financial experience at Guwahati University, where I was junior internal auditor come liaison officer. And the last column shows that I worked for 18 years, 5 months, 28 days at that post.
Then,
Your Lordship, the second next page, Your Lordship, I have served as finance and accounts officer at the Assam Science and Technology University for a period of 9 years, 8 months, 11 days. And this is pay level 13, Your Lordship. Initially, when I was appointed on 1/7/2013, that was at pay level 12. So even if I have 8 years of experience at pay level 12, I qualify, Your Lordship. Here I have both pay level 12 and 13. I am actually overqualified, Your Lordship, for this. And my total administrative experience amounts to more than 28 years. They require only 15 years. And this post of finance and accounts officer is equivalent to the post of deputy registrar. Here I have served for 9 years, 8 months, whereas they require minimum 8 years. They say that they require only administrative experience, and Lordship, that I have. It is not defined what it would be, Your Lordship. Next, Your Lordship, they have shortlisted the candidates, where my name is not shortlisted. The reason for not shortlisting me is provided.
you're coming back to you, Mr. Dick. Please come back to page number 18.
Yes, Lordship.
15 years of administrative experience,
Yes, Your Lordship.
of which 8 years shall be as deputy registrar or an equivalent post. Now, the service that you rendered
Lordship.
as junior internal auditor come liaison officer
Lordship.
or the finance and an account officer and public relation officer in charge of the PIO of the RTA methods is equivalent to deputy registrar.
Yes, Your Lordship. Finance and accounts officer is equivalent, of which I have 9 years, more than 9 years, 9 years, 8 months of experience.
So you want to say that in spite of having such qualification, you have not been shortlisted. Your
Lordship.
name was not there in the program.
Yes, your lordship. There is a
Any reason?
document of
I
the
received
state
instruction
government.
at place before your lordship. I have received a written instruction from the university. Close two.
Yes, Mr. Day.
Lordship. Tomorrow, your lordship, is the interview schedule, your lordship, for this post. I have an interim prayer that I may be allowed to sit for the interview, your lordship. And otherwise, as per what is the criteria mentioned in the advertisement, your lordship, I have showed to your lordship that I have more qualification than what is required, your lordship.
If your lordship permits me, your lordship.
Sure, why not?
Lordship, Lordship, ultimately, your lordship will find your lordship. Your lordship, if your lordship come to page 31 of my writ petition, your lordship will find the notification issued by the governor of Assam, your lordship. The deputy register post, your lordship, will come to page 31. University, your lordship. I am in Assam Science and Technology University, your lordship. Deputy Registrar and equivalent post, your lordship. This is a registrar and equivalent post. Then 3 and 4 deputy registrar, your lordship. That your lordship will kindly see academic level is 13 and 4 is 12. Your lordship. Now it is clear that my post is equivalent to the deputy registrar. Now in these cases, your lordship, equivalence will have to be constituted from the pay level they are drawing, your lordship, not nothing other than that, your lordship. And your lordship will find, your lordship, the ground of rejection, your lordship will find, that is at page 28. Page 28, your lordship, serial number 38. Devojyoti Goswami. Insufficient experience at appropriate level. That cannot be a ground, your lordship. What is that appropriate level, your lordship? You will have to be specific, very specific, while making this rejection, your lordship. That at what appropriate level? Appropriate level experience, as they have been said in the advertisement, is, your lordship, at so far as the deputy registrar and equivalent post is concerned, 8 years of experience, your lordship. That palpably I have, your lordship.
Okay, Mr. Botakur,
Lordship.
this page 28,
Lordship.
the continuation of page 27, right?
Lordship, 27, 28. This is the, your lordship, list of provisionally shortlisted and list of candidates not shortlisted. Now, your lordship,
Now,
as an employer, their power to shortlist and not to shortlist, it is always there, your lordship. That I have, your lordship, no quarrel on that, your lordship. What I am on, your lordship, that the ground of rejection, if I come within the zone of consideration by advertisement, by the requirement laid down in advertisement, you cannot put me out by saying that I have no experience at the appropriate level. And in that case, you have mentioned in the advertisement itself that you will exercise that power to shortlist candidate based on experience on this post, your lordship. And had it been a case, your lordship, that the equivalent post is not there in the advertisement, then also matter would have been different, your lordship. Therefore, my humble prayer at this stage would be, your lordship, this is an, your lordship, what do you mean by experience at appropriate level? This needs to be executed by this honorable court, your lordship. And if that is to be adjudicated by this honorable court, your lordship, my humble prayer will be, your lordship, let me be allowed to participate in the selection process, your lordship. My result may be, your lordship, put before this honorable court in seal cover, your lordship. If I don't qualify, your lordship, then ultimately this petition will become infructuous, your lordship.
just tell us one thing. This 23rd of notice that was issued on 23rd of August 2024.
Lordship. Delay, your
is up to 29 pages, right?
lordship.
Can we come to page number 29, the last portion?
Lordship, I have seen, your lordship. In case of the query, only non-shortlisted candidates may submit their representation through email mentioning subject line so and so, so and so. This is, your lordship. But
when did you ask for it?
As per their instruction 8.
All these non-shortlisted candidates were given an opportunity.
Lordship.
Right? to
Lordship,
make the queries.
Lordship.
Did you make the query?
No, your lordship, I did not make your lordship because your lordship, what has happened? They have put it in their website, your lordship. That has not been normally, your lordship. Any rejection, your lordship, they have your lordship through email, your lordship. They inform the candidates, your lordship. That has not been done in the instant case, your lordship. That is there, and your lordship.
It was in the website, right?
Lordship, it is in the website, your
Shortlisted
lordship.
candidate as well as the non-shortlisted.
Lordship,
And for the not shortlisted candidate,
lordship,
that means the chance was given to them to
Lordship.
know the reasons,
lordship.
right? Have you taken that opportunity or not? Did you comply
Lordship,
with that?
that I have not done, your lordship. That is apparent, your lordship. I have not annexed anything on that, your lordship.
No, that's
Your
that
lordship
is-
will kindly see, I have made a statement, your lordship. Para 6, your lordship, that the petitioner being eligible as per the norms stated in the advertisement so and so within the specified date. It is stated by the petitioner that on 23/8/2024, the university has uploaded the list of provisionally selected candidates for the post of vacancy and also for the list of candidates who were not selected. May appear serial number who are the authority has cited insufficient the ground of rejection. The petitioner was initially not aware about uploading of the said list as he was under the impression that
all
he
will
would be.
settle that you know, you are aware or not aware.
Lordship,
That it is not the individual email, no?
Lordship.
It has to, because
Lordship.
the order of the apex court is very clear
Lordship.
in this regard. If you would have
And in
submitted your
fact, your
application
lordship,
in time,
on
let
8,
us-
your lordship, there is an email from our end, your lordship.
No, whether it was within time or not.
Yes, your lordship will kindly see the page 29, your lordship.
Because time limit was given 28th of
28,
August,
your lordship. 28.
2024 by 12
Lordship.
noon. So when did you send the email?
But that your lordship after this date, your lordship. But ultimately, your lordship will kindly see.
You can understand.
Suppose your lordship, for a moment, your lordship.
See, whatever the things you are asking for now, if you would have applied in time, they would have informed you.
Lordship.
If you have not availed it, now can you ask for it?
No, your lordship, my case is this, not that your lordship, that they should provide me the reason for not, for rejecting my candidature, your lordship. My case is that, your lordship, this rejection itself is bad, your lordship. Whether I wrote to them.
That is why we are asking you.
Lordship.
You have been given an opportunity to know the
Lordship.
reasons, right?
Lordship.
To why your candidature has not been considered.
Lordship.
In that circumstances, you have not availed that opportunity.
Lordship.
Now filing this writ petition, you are asking for it, saying that it is bad. One thing is that when you have been given an opportunity, you have not considered it. Now filing this writ petition now, just before the one day before the interview, will you help it? Because how will you fulfill these criteria of the writ petition? That is the thing we are asking you. If it had been a case that you have applied for pursuant to this, first of all, you have not been shortlisted.
Lordship.
You have filed the appropriate application to know the reasons why you have not been shortlisted. And if there are some vague grounds was given to you, have vague grounds have been informed to you, then you had a different kind of a case, right? Then, but here you have been given a chance, which you haven't availed.
Lordship.
Now at this stage, because tomorrow is the interview.
Lordship.
The thing is this, at this stage, how can it? These things you must consider in that aspect. You have not availed, now you are running here for the direction to allow you to sit in the interview.
Lordship will kindly see.
You definitely had a good ground. But thing is this, first of all, you should have known in that case, if you had been informed a similar ground, that insufficient experience at the appropriate level, then definitely think we had a chance. But now you have not availed the opportunity.
Now your lordship will kindly see, your lordship.
Even if we allow you,
Lordship.
let us assume that we allow you to sit in the interview. But ultimately, what will happen?
Lordship will kindly see. Ultimately, your lordship, I may get selected or not, your lordship. May not get selected. But your lordship will kindly see if
your only case is that you fulfill the criteria.
Lordship.
As because pursuant to the notification of the state government,
Lordship.
you are at the level 13.
Lordship.
serving as, because your pay scale is at your level 13 and the requirement is only level 12.
12.
But already you are already in level 13 for the last 8 years or 9.
Lordship.
That is your case.
Lordship.
You want to know the extra reason.
Lordship.
What is the insufficient experience?
Lordship. Not, not only that, Your Lordship, if I qualify for this, Your Lordship, under this advertisement, Your Lordship, then there may be extra reason, Your Lordship. That extra reason cannot be the ground to reject my candidature. That is my case, Your Lordship. If Your Lordship is satisfied that the reason given by them is not vague, it's very specific, and it as per the advertisement, Your Lordship, given by the Tezpur University, then I have nothing to say, Your Lordship. It is since Your Lordship's satisfaction is there, Your Lordship. But if there is a semblance of Your Lordship confusion about the vagueness in their instruction, which I am not privy to, Your Lordship, then Your Lordship, probably prima facie I am entitled at least to sit in the selection process, Your Lordship. Whatever be the outcome, Your Lordship, that's a different matter altogether, Your Lordship. Ultimately, Your Lordship may decide it against me, Your Lordship, that the employer has the power to do that. But on the face of what has been placed before this honorable court, Your Lordship, this advertisement, Your Lordship, as per this advertisement, I fulfills the criteria, Your Lordship. This is my case, Your Lordship.
Yes, Mr.
Lordship has seen my written instruction.
What Mr. Bhattakuri is saying, if you have to see that page 18.
Lordship.
"15 years of administrative experience, of which 8 years salary as deputy registrar or equivalent post."
Or equivalent post.
Now coming to page number 29, not 29, yes, 24.
Lord.
Here, from 1st of July 2013, he is serving in that post and drawing a salary of 37,400 to 67,000, with grade pay of 8,700 at pay level 13. For that purpose, he has given this order of the state government at page 31. The level is 13. Right?
Lordship.
And your requirement is, as per the advertisement, deputy registered equivalent of 8 years. He is in level 13, whereas here is a case of level 12, and he is above one level.
Lordship, please to see page 18, 1. For registered administration, a master degree with at least 55% mark or equivalent grade in a point scale wherever grading system is followed. And 2, at least 15 years experience as assistant professor in academic level 11 and above, or with 8 years service experience in academic level and above include associate professor. He is not in teaching line, Lordship.
No, that I am not.
Then comparable experience in
No, that is the reason, that is the reason you have 3 grades. Those who are not from the academic side,
there.
for them there is a or.
Second, Lordship.
Yes.
15 years administrative experience, of which 8 years will be as a deputy registrar or equivalent post.
Or an equivalent post.
Lordship.
So 8 years, he has more than 15 years of service.
But Lordship, his experience as per his application, page 23 last, administrative and junior internal auditor come liaison officer. Then page 24. At present, he is serving as finance and account officer and PRO in charge, PIO of RTI matters.
He is a public relation officer.
Yes, sir.
No, yeah,
and also in charge of the, under the RTI Act.
But whether it can be considered as a.
Why not? Liaison officer,
Lordship, my written instruction, point number 4.
please come to page 22.
Page
22.
22. Lordship.
Down below. Present employment
Present
details.
employment details, number of name of post, finance executive officer, type of permanent, date of appointment 1/7/2013, employment name Assam Science Technology, pay band so equivalent 13, gross equivalent so, age of retirement 60 years, date of retirement, the present post 31 to 31, whether you are receiving any pension, no.
So in fact, your lordship, in number of universities, I have been allowed to participate in the, I did not bring it into record, your lordship. I have been allowed to participate in for the post of registrar, your lordship, even in KKH University, your lordship. My only consideration is this, your lordship, if it happens in one case, your lordship, it may be a ground for my future also, your lordship, future rejection, your lordship. That's the only concern, your lordship. Otherwise, your lordship, that's why, your lordship, I want it to be, your lordship, decided, your lordship, by the honorable court, your lordship.
Third, Mr. S. Botrapu, counsel appearing for the petition. And Mr. S. C. K. Counsel. Standing counsel for the Tezpur University, respondent numbers, representing respondent numbers 1 to 3. Will you also say for 4?
Lordship, I can accept.
Mr. Hale and counsel as CGC also appears for the respondent number 4. Take your seat.
If your lordship permits me to go, another matter is going on, your.
Please go ahead.
Deeply obliged.
For various posts, the authorities in the register, the acting registrar of respondent Tezpur University will indicate a central central university. While advertisement number 05/2024 dated 14/03/2024 issued an advertisement including one post of registrar within bracket administration in it. Seeking applications through online mode from eligible interested candidates. Giving the details of advertisement and other terms and conditions in the website of the said university, fixing last date and time for submission of field desk in applications through online portal as 15/05/2024 up to 11:59 PM Indian Standard Time. The petitioner considering himself to be eligible for the post, for the advertised post of registrar in bracket administration in Passport University as advertised on such and such date or advertised number such and such. Applied for the said post. Stating that he served as junior internal auditor cum liaison officer at Guwahati University for the period from 02/01/1995 to 30/06/2013 for about 18 years, 5 months, 28 days. In the payment of ₹8,000, that's 3,500. With a grade pay of 4,600. 85,000 করে দেবো, 5,000 slash লিখো pay level at ₹22,000 তিনটা 0, that's 870. And thereafter, since 1st July 2013 till 12th of March 2023, as Finance and Accounts Officer, PRO, Public Relation Officer, in charge of PIO of the RTA matters in the Assam Science and Technology University for 9 years, 8 months, 11 days. The pay went in grade pay of ₹37,400, that's 67,000. Grade pay of 8,700. Pay level 13. The respondent university on 23/08/2024. No, respondent university, respondent for university wide notice dated 23/08/2024. Published thirteen numbers of candidates as shortlisted candidates for the post of registered administration as advertised on along with a list of containing 66 candidates who are not shortlisted for the said advertised for the said post. That includes the name of the petitioner, serial number 38. Showing the reason for not shortlisting as Udin colon লিখিত, insufficient experience at appropriate level. Petitioner submitted that tomorrow I get to her. Is the date fixed for interview for the said post of register administration Westport University as advertised on even by the advertisement number. It is also stated that since he fulfilled the criteria of 15 years of administrative experience, including 8 years as deputy registrar or an equivalent post, with M.Com degree in accountancy with 60% from Guwahati University. MPhil degree from India 2023. PhD on 11/08/2021 from KK Handy, SOU, right? The University, State Open University. PGDM 18/09/2014 on management functions, behavior, magnetic public management, human resource, economic and social, environment management, AI applications development, and strategic management from Indira Gandhi National Open University, Green Bucket Technology. An LLB degree on 16/7/1999. Guwahati University. He is eligible by academic qualification as well as experience for the safe post of such. The petitioner has also placed a communication or a notification. Notification number FPC.60/2017/52 dated 04/09/2018 issued by the Finance Union Pay Research Unit Close Department, Government of Assam, to show that he is when drawing the scale of pay of ₹37,400 to ₹67, grade pay of 8,700, which is academic level 13 for the last 9 years, more than last 9 years. At academic level 13 of the university, much above the requirement specified in the cited letter in such petition. But the respondent university simply placed him in the list of not shortlisted candidates, specifying of insufficient experience at appropriate level. Next, Mr. Kell, standing counsel representing the respondent Westwood University, placed before the court that the notice dated 23082024 issued by the respondent Westwood University, wherein the name of the petitioner figured at serial number 38 among the list of candidates not shortlisted for the post of such, clearly indicates that ample chance was given to such non-shortlisted candidate to make their queries by submitting their representation through email, mentioning the subject line as within colon detail. Registered by notification number 05/2022 dated 14/03/2022. Notification or active. To the concern address of the university, latest by 28/08/2024 12 noon, indicating further that any correspondence made after the due date slash correspondence made in any other email ID slash correspondence without the above subject line shall not be entertained. Mr. Kell submitted that in spite of giving opportunity to know the specific reasons for placing the petitioner in the list of candidates not shortlisted for the post of such and such, comma, he did not file any query. He did not file any query for rejection of his candidature for the same post within the time so specified. And that said notice dated section 23/2023. On being admitted or on being inquired, it is submitted on behalf of the petitioner that he did not submit any such, he did not send any such email within the time so specified, making query to know the reasons for such and such why the candidature. But stated that since he fulfilled all the requisite eligibility, the respondent authorities simply cannot sideline him, placing in the list of candidates not shortlisted without clarifying the underground of insufficient experience at appropriate level. Without clarifying such appropriate level. It was reiterated on behalf of the petitioner that having all his academic qualifications been fulfilled for the post advertised, for the register of administration post as advertised, and also having the sufficient experience as required for the said post has been advertised, and having been at level 13 for the last more than 9 years. The respondent university simply cannot reject his candidature, not having sufficient experience at the point. Next. Mr. Kerr also pointed out, okay, Mr. Kerr on behalf of the respondent university also pointed out that the petitioner in his application submitted on 15/05/2024 for the post of registered administration advertised on 05/2024 for registered admission advertised on towards his experience stated that he served as finance and accounts officer, public relation officer, in charge of PIO, PRTI matters in the UST, ASTM. For the period from 01/07/2013 to 12/03/2023, but did not state as to what he is doing after 12/03/2023. Did not mention about his occupation, like not doing, like, but did not mention it after 12. It is also submitted by Mr. Kell and the council that on 14/03/2024 in the concern advertisement number such and such itself, the respondent Tezpur University specifically provided that mere fulfillment of minimum eligibility criteria shall not entitle a person for consideration, and the decision of the screening committee within bracket small s committee staff for shortlisting of candidates shall be final and binding. And further, the university reserves the right to fill up or not to fill up any of the vacancies. As in the case in hand, the concerned committee, screening committee, did not shortlist the name of the petitioner for the post of registered administration Tezpur University as advertised on such 1403. Because of not having sufficient experience at appropriate level, the said decision of the screening committee of the responding university is final. On perusal of the application of the petitioner dated 15/05/2024 for the post of registered administration at Tezpur University, advertised on 14/03/2024 by advertisement. It is seen that under the heading present employment details, the petitioner have stated that he is serving as finance and accounts within bracket and accounts bracket officer. The Assam Science and Technology University in the pay band of rupees 37,400, that's 67,000 for the paid job 88,700. Since being appointed on 1/01/07/2013 in a permanent post. And date of his retirement is 31/01/2031, attaining of 60 years. Indicates that the petitioner is still serving. The petitioner was serving. Petitioner has been serving in the Assam Science and Technology University on the date of his application on 15/05/2022. From the reading of the advertisement dated 14/03/2024 relating to the post of registered administration, it is seen that the petitioner has the requisite academic qualifications, who doesn't have the teaching experience. That is not required, since there is another provision, another eligibility. Instead of teaching experience at 15 years of administrative experience with 8 years as deputy registrar or an equivalent post. The court is of the prima facie view that the petitioner fulfills the criteria for the same post. So notice returnable by 6 weeks. As Mr. S. C. Carroll, standing counsel party in Tezpur University as well as London Central Government Council received notice for the respondent numbers 1, PO3 and 4. No formal notice need to be issued to those respondents. Petitioners also have requisite extra copies of this petition along with the annexes appended thereto to Mr. Cal during the course of the day, obtaining necessary acknowledgement from him. Has been stated that the advertisement before the post of registered, the single post of registered administration in Tezpur University, pursuant to the advertisement dated 14/03/2024 by the advertisement number 05/2024, it speaks tomorrow I. In the interim, the petitioner shall be allowed to participate. By the respondents and the test authorities in the university shall allow the petitioner to participate in the same interview. And the respondent university shall keep the marks secured by the petitioner and said university in a sealed cohort. Or without the leave of the court, the respondent for university shall not declare the post, the result for the post of register administration as advertised on such and such right number. List type.
Lordship is directing us to allow him to
Participate. Since this order has been passed in presence of Standing Council, Testpool University. Such and such. Like, he shall intimate the authority allowing the petitioner to participate in it. It will be uploaded. Just I'll come back in 2 minutes.
Yes, Mr. Veera.
May I please, your lordship? My lord, this matter relates to claiming of pensionary benefit, my lord. My lord, my late husband was working, my lord.
Why they are refusing to grant it to you?
My lord, they are now intending to give me only pro rata pension, my lord, not the.
What is the ground for not giving it?
Lord, they are saying that the service tenure in the Assam Higher Secondary Education Council do not come within the purview of the tenure of service which is required, my lord, for the purpose of getting the regular pension. Now, my lord, there is a merger of my service, my lord. In the higher education department, my lord, I was working for more than 30 years. And then I have shifted, my lord, to this, my lord, Assam Higher Secondary Education Council and served, my lord, for another period of more than 10 years, my lord. So now clubbing both the service, my lord, I am eligible and entitled. But the council says, my lord, that as our regulation do not meet the norms, so therefore we cannot give the benefit, my lord. That is the crux of the case, my lord.
Pension law.
Higher.
এই আসাম মেঘালয়ত থাকিব
আচ্ছা
সেইখন দিলেও হ'ব পুৰণা হয়
pension memo. My lord, the council is maintaining a separate regulation, my lord. The last time it has been submitted by respected senior Mr. T. Chutia, sir, my lord. The records has also been called for.
My record is always like this. মোৰ কথাটো হৈছে কি তাত 7 years কৰিব সেই অপশ্যনটো তেতিয়া কাৰণে সেইটো ৰিপৰ্টৰ কাৰণে কৈছে ৰিপৰ্ট কৰি দিয়ক অপশ্যন বেলেগ নাই সেইটোৱে মোক আমাৰ মতেতো এতিয়া আমি ঠিকেই দি আছো আমাৰ নাপায় তথাপি দিছো সেইটোৱে ৱাইফে আমালৈ কৈছিলে কিবা আৰু বহুতখিনি হৈছে ষ্টুডেণ্টক কৈছে হয়নে ধুনীয়াকৈ লিখিছে এইখিনি এটা লিখিছে তুমি কাটি দিছে এখন আছে ৰিমুভ কৰিলে হ'ল আৰু আছে আমি লিখিছো 44 কৰিলে হ'ল Mr. Gogoi. Let me see pension rules 1969.
Rule 98, Losik. Rule 98.
234 and 235.
234.
I don't know what is the name. In my book, it is 234, 235, the old book.
234, 235 page, Losik.
Not the page, rule. 1969 rules. Is it there?
Otherwise, here Losik rule 98 is applicable.
The concerned person has already expired. His wife is seeking for such family pension.
That is there, Losik. It is not a disputed fact. That is there. Otherwise, also, Losik. Here in this case, Losik.
What we are saying.
Losik.
It's not a deniable fact that petitioner's husband did not serve in the council.
He is permanently absorbed.
Thereafter, subsequently, permanently absorbed.
Permanently absorbed here, Losik.
So earlier he was under the Directorate of Higher Education. Then subsequently he was in the.
Losik.
Now,
Lordship, by applying the principles which was prescribed in the pension rules, rule 98, Lordship,
As per the rule 98, our duty is to calculate the pro rata pension and leave encashment losses, what amount he is entitled
During that period,
during that period.
when
and
he was
we-
an employee of the,
Yes,
under the
yes,
directorate of
lordship,
Higher
lordship. And lordship, we have to send it to the Seva lordship, then they have to calculate and give him lordship. As per rule 98 lordship. Otherwise also lordship, secondary education rules, rule 4 lordship specifically says that all are their lordship. Everything they have to done lordship. As per.
Mr. Sutia, as
Lordship.
in Mr. Gogoi been saying, what kind of pension you are supposed to provide to your employees?
My lord, I have received the record. The record says, my lord, the already petitioner, my lord, petitioner has accepted for the pension from us. Lordship kindly see it, my lord.
First, show it to Mr. Via.
Lord,
We are
I
not
have-
it.
I have the
Copy.
side.
No, have you copy दिया? Lordship का.
Now, once if he has accepted pro rata pension,
Accepted,
during
my
his
lord.
lifetime.
And she has no grievances against us, my lord. They have expressed.
Sir, my lord, the language of the letter is like, my lord. Sir, may I request you to take on the issue if officially possible with the Commissioner Higher Court that I find a way to resolve the higher education part of the pension at the earliest. My lord, it is not that I am directly accepting the, my lord, pro rata pension.
directly, indirectly.
It
what is
cannot
that?
be interpreted like that.
My lord, though it covers only less than 20%, let BC Goswami's total service period, I welcome the. No, my lord, the issue is the question involved here is regarding the application of law, my lord. Whether this acceptance of the pro rata pension, my lord, can waive the rights. My lord, my lord,
Where is your letter, Mr. Sutia?
This one, my
Give
lord.
us a copy of your letter.
Yes, yes, my lord, record. We are just.
my lord, my respectful submission, my lord, regarding this letter, my lord, is that even if, my lord, there is an acceptance of pro rata, if for the sake of argument, if I admit, my lord, that, my lord, that will not waive my rights, my lord. The rights of getting the regular pension, my lord, as per the rules, statutory rules. Now, my lord, my late husband admittedly, my lord, served more than 37 years in the higher education department. And therefore, my lord, I came back here as initially in the deputation, my lord. Thereafter, a technical resignation has also been accepted. And now, my lord, before the service period which I did render in the SEBA, my lord, that does not, admittedly, my lord, that does not fulfill the regulation of the SEBA, my lord. The length of service which I am required to render, my lord. That is admitted. But, my lord, if I club the, my lord, both the tenure of service in both the departments, my lord, then it come down, my lord, the earlier past service cannot be, my lord, wiped out. My lord, to that effect, I have a judgment passed by this honorable court also, my lord.
One thing, my lord, I am.
Lord, the various communications which I have annexed in my writ petition, my lord, has also a bearing on the issue, my lord, that the higher education department is relying on the, my lord, SEBA, and SEBA is relying on the, my lord, higher education department. That type of, my lord, communications are repeatedly going
Mr.
on.
Via, when the husband of the petitioner left the Pragjyotish College?
Yes, yes, my lord, my lift on, my lord, 1995, my lord. Since 5/8, I did work, my lord. Initially 5/8/1964 to 4/1/1995, my lord.
Page 44, lordship, petition, lordship will get all these things, my lord.
Page
Yeah,
44, yes,
44.
yes, my lord, the page 44 is the
Dated
entire.
20th July 2017, lordship, kindly see. The small thing is that that can be removed by the principal secretary. Well, may I read it, my lord? The letter, page 44, annexure 12, letter dated 20th July 2017, wrote to the principal secretary higher education by the director of higher education. With reference to the subject cited above, I have the honor to inform you that late Bireshwar Chandra Goswami, the husband of the petitioner, served as a lecturer in the Procedural College with effect from 5/8/1964 to 3rd of January 1995 for a period of 30 years, 4 months, 29 days.
Just a minute, let us wait for it. During this period, up to 3rd of January 1995,
Yes,
the college was not provincialized.
not provincial.
So in that case, the
Granted
question
it.
of,
Granted it.
that was what? 50-50%,
50-50.
50% to be deposited by the petitioner and rest of the person. to the
Yes, yes,
government.
CP.
It was the protection
Yes,
given there because there was no, since there was no provincialization.
Yes.
Question of giving pension doesn't arise. It is only after 1st of December 2005.
5 million.
That is CPF,
CPF.
contributory
Milord,
provident fund was there.
that CPF I have
Now-
also returned back, Milord. Some amount, Milord, which I received, Milord, as a CPF that has already been taken away from me, Milord.
By whom?
By the higher education department, Milord.
When?
Lord, it is,
Page 50 is DS deposited.
my lord.
Page 50.
50, Milord.
Within the time frame that was extended by the FRBM,
Extended.
that was extended.
My lord.
That can be removed. That's why page 44 I am pointing out.
Is extended.
Only option was not given, no?
Yes, returned the CPF. So we have calculated to send it to the Seval.
No, we will have to examine, my lord, whether petitioner serve in the Procedural College more than 30 years and resign it and work in the SEBA only for 7 months, 2 days. That is not qualified service for pension also. Whether the petitioner will get the pension from this college, higher education or SEBA. Our regulation is clear and case law also is clear. When there is a resignation, there is no relation in between the employer and the employee. And he resigned it, and that's why his past service cannot be counted. SEBA cannot taken into his past service for calculation of the pension. Case law is clear. And this letter, why I am pointing out, matters would be.
In this record, do you have the advertisement?
Yes, direct recruitment. We have made an advertisement.
Do you have that record?
Record, yes, record.
In this particular record, do you have?
Yes. Black mark is there mostly. Hello. Advertisement also, petition also.
I have.
In petition also.
Section 98, the division part was also dealt with.
It is a technical resignation, my lord. My lord, advertisement, my lord, may be pleased to find in my petition, my lord, is at page, my lord, 19.
19, huh? Yes. Direct recruitment. 19.
Now, my lord, those people who has the teaching experience of 10 years, which 5 years must be teaching preference to the candidate having higher academic distinction. So and so, my lord, there is a connection with the earlier service also, my lord. Lord, a small, my lord, annexure 3 at page 22, my lord. If my lord may be pleased to find the copy to market serial number 3, my lord. My lord, may kindly have a perusal of this point, my lord. Principal Pragyatis College, Guwahati, for information and necessary action with reference to his letter number so and so. He is requested to send the service book of Sri Goswami and the amount of CPF due to him to the undersigned with detailed account of it. So, my lord, this means that the SEBA, my lord, the Board of Secondary Education has taken up the responsibility of.
No, that CPF should have
No.
been shifted from
For
the side of
performance of
the
his service.
No. What would have been happened?
Yes.
Mr. Sutia is like this.
My lord.
Till then, when this letter was written, it was in the question of provincialization was not there.
That is
So
correct.
whatever shifted earlier, the CPF amount, the contributory amount, 50% of contributory amount to be given by the government,
Mal.
now would have shifted to SEBA. He would have continued to pay 50% of his share, and as the CPA, the SEBA would have contributed 50% from it. It was his CPF amount. That is why the service book was sought for.
No,
to
Sabik
show-
was, I have been informed, my lord, by the secretary. I asked him about this, my lord, number 3, OP. He said, for confirmation his service, this service book was required, but they did not submit it. They did not submit it, they did not respond to this letter.
No.
Yes, they did not submit the college. So this clause, principal prejudice college for information and necessary action with reference to this letter so and so, he is requested to send the service book of Sri Goswami and amount to CPF to the office, other side, the detailed amount for it. That was not responded by the college authority, did not send it. And petitioner ultimately, what happened, my lord? When he not willing to go back to the prejudice college, it amount to, my lord, resignation. And after resignation, there is no relation between the prejudice college and with the ballot petitioner, because his relation is cut off. And he joined in our SEBA office ballot through advertisement, that is through ballot direct recruitment. And the advertisement says he should come through proportional, but he did not apply proportional. He could have come through the Director of Higher Education. It is a proportional. At that moment, Director of Higher Education is the controlling authority of the government. That is the position, my lord. That is the position. As per our regulation, my lord, one person who has to be qualified for a pension, my lord, only he completed 10 years minimum service and more than 25 years for full superannuation, pension for full superannuation. Now he has completed only 7 years, 2 months, less than qualified service. Even though we have on sympathy ground, my lord, we have written this records, my lord, we have given her a pro rata pension from our that has been sanctioned and that has been received by the petitioner. And she has no any grievances. My friend, my lord, Bhuya is interpreting this letter, my lord, it is what compulsion? There's a voluntarily she has accepted, she has thanks to the ballot, she has given thanks to the SEBA that yes, now she will ask the ballot SEBA to help from the higher education. That was the ballot contention of the letter, no, nothing more. And regarding the ballot counting of past service ballot, I will argue it better, and also I'll provide the cash flow also ballot. The clear cash flow is there. And what is the resignation, my lord? Resignation, they say not resignation. But when he not willing to go to the prejudice college release him because he did not intend to go back to the prejudice college. That's why his amount to resignation. I have the cash flow, my lord. I will show it. Supreme Court says this under this circumstances it is deemed to be resignation. And when he resigned it from the prejudice college, then petitioner has no relation with the prejudice college, my lord, and his past services cannot be counted. So he served prejudice college more than 30 years. So he should get pension from the, my lord, prejudice college, higher education. And our department, SEBA has already done whatever is to be done, my lord, in his sympathy gown, already given pro rata pension. And lots of Milord, regarding this service book clause, Milord, which has been inserted in the letter, Milord, it itself reflects, Milord, that there is a connection with my past service, while the Milord SEBA has accepted my joining. Why I am respectfully back to submit, Milord, is that, Milord, if it is a direct recruitment, then they could have opened a new service book, Milord. There is no question of asking for the old service book from the college, Milord. And secondly, Milord, regarding the Milord resignation, it's a technical resignation is always there is a provision, Milord, under the pension rules and the other provisions also, Milord, is there. Now, Milord, the issue is that, Milord, whether my past service of more than 37 years can be wiped out or goes in vain, Milord. That cannot be, Milord. And in the advertisement, they have said that the teaching and administration for 10 years of which 5 years must be in teaching preference, Milord. Then those persons, Milord, who were working at that relevant period of time as a lecturer or in the Milord post of professor, Milord, they are only entitled and eligible, Milord.
Mr. Gogoi, Earlier also sometimes probably have looked into this case. Uh, just see, there is a reported judgment.
I guess. He was primarily observed.
You have that judgment, that's
Well,
the
this-
H. judgment, right?
This is the judgment.
I remember. Now, thing is this, in that case, what happened? He went from Assam Engineering College to Guwahati
In
University.
paragraph 9, in that particular judgment, my lord may kindly peruse paragraph 9.
No, just tell us the fact that he left Assam
He
Engineering
left
College
to
and joined Guwahati University.
Guwahati University, but he was not permanently observed in the Guwahati University, lordship. And that's why, lordship, the pension part responsibility sent to the directorate, lordship. Here the case is totally different. Here the particular person is permanently
In
observed in the
that
seva.
case, this reported judgment, in that case, the petitioner therein
Lordship.
was not permanently absorbed in the Guwahati.
Guwahati University, lordship. Paragraph 9. My lord may kindly peruse paragraph 9. Paragraph 9. Okay. Listen up. Lordship permit, I can read it, lordship.
No.
In the instant, paragraph 9, lordship. In the instant case, the petitioner has not resigned from his government post of professor of the engineering colleges. Thus, the question of acceptance of his resignation from the said post does not arise, lordship. And the petitioner also was not employed under the body corporate owned or controlled by the government as he was serving in the Guwahati University. That part, lordship, pension rule 98. That body corporate part, that's why it is mentioned, lordship. Which cannot be described as such an entity, lordship. Even assuming that the Guwahati University can be described as a body corporate owned or controlled by the government, lordship, the employment of the petitioner with the Guwahati University was only on deputation basis, and he continued to hold lien in his substantive post of professor in the engineering college. His lien was there, lordship. Here in this case, lordship, lien was, lordship, end in the 1998 itself, lordship. 1995 itself, lordship. That is the difference between this particular case and the present case law.
But ratio of law will govern same way.
And here, lordship, he is not permanently absorbed, so burden shifted to us. And in the particular case, lordship, the particular person's lordship permanently absorbed in the seva. So as per the applying the principles which was prescribed in the pension rule 98, lordship, that burden goes to the seva, lordship. And paragraph 10 also, lordship. আপনার manual মূল্য নেই Solution আপনার manual যারা কি কিতাব লিখেছে পাত্তা নেই
এইখন
Mr. Gogoi,
Lordship,
just tell us one thing. Once the petitioner deposited to
Lordship,
the treasury of the government,
Lordship.
the dues that was given to her, the
He-
CPF employee.
Lordship, Lordship. Then,
Any
Lord,
such employee who, assuming the petitioner husband,
if he was in the Prajudice College, Lordship, he retired from the Prajudice College, Lordship, then he will shifted to the pensionary. That he'll entitled for
we are
pension.
not on that.
Lordship,
Assuming he was in that college
Lordship,
up
Lordship,
to 3rd of January 1995,
Lordship, Lordship,
right?
Lordship,
Or 2005.
Lordship.
He was serving up to
95 million.
95.
Lordship.
And as per the term given by the government in extended
Lordship,
period,
Lordship.
he has deposited the government share
Government
of
share.
CPF
Lordship, Lordship,
till that particular date,
Lordship.
whether the petitioner will not be entitled for pension.
Lordship, yes, because he's permanently absorbed the another department. If he was in
No,
the,
we are not on that.
no, no.
We are not on that. Because see, it's the case
If
that-
Lordship, he is superannuated from the Prajudice College,
not
Lordship.
on- see,
No.
SEBA is not giving him the pension
Lordship, Lordship,
because he did not fulfill the 10 years.
Lordship,
term.
Lordship.
And in fact, there is a division bench judgment in that.
Lord, now Lordship has to decide the moot question, Lordship, whether the particular period which was spent by the petitioner in the Prajudice College can be counted for the pensionary benefit or not. That part Lordship has to decide. Otherwise, Lordship, the CPI amount which was deposited by the petitioner, if we go by the prescription prescribed by the Statute Lordship Rule 98, Lordship, we have to send it to the body corporate, Lordship. Body corporate is as per section 4.2 of the 1961 rules. It is the Lordship SEBA. And so we have to send it to the SEBA, Lordship, by applying the principles of the prescription prescribed by the Statute, Lordship. If
you forward, let us assume that
Lordship.
you will forward that amount.
Lordship,
What kind of pension the petitioner will get?
then Lordship, they SEBA have to calculate it, Lordship. Whether they have Lordship calculated the period to past service to be a continuous service or not. Otherwise, Lordship, they have to given the pro rata pension in what amount, Lordship. They have to calculate it.
Education service.
They have to calculate it.
Assam University, Guwahati,
Every summer from there.
1961.
Lordship, kindly, before that, Lordship, for that purpose, both purpose, Lordship, first kindly peruse Lordship 98 of the pension rules. Then the picture.
No, that 98 relates to pro rata.
98 Lordship wording, so Lordship kindly peruse for a moment 98. Then Lordship will come to the 4 to Lordship. 98.
You just read.
98, just I didn't read Lordship.
Yes.
Note 1, Lordship. In case of a government servant who is deputed or transferred to service under a body corporate owned or controlled by a government or whose service are lent to such a body, and in the event of his resignation being accepted by the permanent absorption in the service under that body, my lord, may kindly mark it. An amount equal to what government would have contributed had the officer have been contributory provident fund terms under the government, together with simple interest thereon, at 2% for the period of his pensionable service, and the government may be credited to his contributory provident fund account with such corporate body. My lord, may kindly mark it as an opening balance on the date of permanent absorption, Lordship. Government's liability in respect of the officers' pensionable service under them shall be treated as extinguishes by this payment, Lordship. My lord, may kindly mark it. This is to be done irrespective of the fact whether such corporate body has contributory provident fund or pension in its side. Then Lordship, the corporate body, if it has a provision of CPF, would credit the amount paid to the government in the CPF account of the individual concerned. And if there is a provisions for pension of the corporate body, that amount would be resumed by the body, and who will then allow the period of the government servant to count for pension admissible at this site. Madam, may kindly mark it. The above decision will apply, however, only where the permanent transfer from the government service to such corporate body is in a public interest. In all other cases, government, that is not Lordship necessary. Then, my lord, may kindly come to 1961 rules.
Rules of the act.
Lordship, Assam
Rules.
Secondary Education Act 1961, Lordship. Rule 4.2, Lordship. In this book, Lordship, 340 page.
No, your rules you are saying.
No, Lordship, 1961 Act. Assam Secondary Education Act 1961, Lordship, page 2340, Lordship.
Correct.
340, Lordship.
No, in this book.
Lordship, this book 340.
Incorporation of the board. Incorporation of the board.
Yes, it is in this book 335.
Lordship, Lordship. So, my lord, may kindly peruse Lordship 4.2, Lordship.
Section 4.2.
4.2. We start from 4.1, Lordship. The state government shall, as soon as may be after the commencement of this act, established by notification a board for regulation, supervision, and development of secondary education in accordance with the provisions of this act. Then, Lordship, this too is very important, Lordship. The board shall, by name of the Board of Secondary Education, by the body corporate with the perpetual succession and a common seal, shall have power to acquire and hold property, both movable or immovable, to transfer any property held by it, to enter into any contract, and to do all other things necessary for the purposes of carrying out of its duties and function, and shall by the said name sue and be sued. That is, Lordship, as per the rule 98, Lordship, the functions of the body corporate, Lordship. It's a statutory prescription, Lordship. Now, my lord have to decide, Lordship, whether that period should be counted for pensionable service or not, Lordship. That moot question, Lordship says answered, then, Lordship, everything will be.
Mr. Sutia, what we have seen that you have fixed his pay as on 4/1/1995 because after his communication, he received a similar amount of salary as he was drawing in Praxis College.
Salary was protected. That is the normal course. Salary is protected. Every employee should not get less than earlier salary.
Now just tell us one thing.
My lord?
What you have given to her?
Pro rata pension has been given because on sympathy ground. Otherwise, not entitled. I am come to the lordship pass service of pass counting.
You will come back at 2.
May please, your lordship. If your lordship permit me, lordship, item number 36 to 39, if it can be upgraded, lordship.
Because there are some admission matters.
14 get taken up.
Let us see. We'll go one by one.
Some other cases are fixed.
One matter.
Whether your lordship will take time. Get time to take up the matter. I have very important matter 14 and 31.
Because one matter was upgraded.
Yes, my lord. In that case,
In 30, I think. There is also a Padhat matter.
Padhat.
So at this moment, we do not know. Let us.
So whether 14 your lordship will be able to take. I've got 2 items, one 14, another 31. Then it takes next week. It is not possible.
Let them come at 2.
Obliged. I will like to be waiting. It will be people or my lord, so many matters, my lord, then my lord, it may fix next week,
We'll adjourn it. No.
next Thursday.
Okay, because we have a partner matter. We have to take up.
Yes, so many matters are there.
Okay.
Let it come on next Thursday, my lord, if possible. 14,
19.
19. Obliged.
May I please, your lordship? So, my lord, I have gone through this judgment also, my lord. The ratio of law which has been fixed, my lord, although there is some distinction between the facts of the case, my lord. But regarding that resignation and termination, my lord, has been negated by this honorable court in the state judgment. And my lord,
There is a reason behind that. If you read that judgment, you will see.
my lord,
Though he went to university, but interestingly, he, during that deputation period,
my lord,
when it was lien on lien basically,
my lord,
he made he wanted to return back
my lord.
and submitted an application in that regard. And that was pending before the Directorate of Higher Education,
That is correct. my lord.
which was not acted upon. And so he continued in the university, and by the time he retired from service.
Retired from-
So therefore, that is in that background of the case, and see his lien continued with the Directorate of Higher Education. That's why the court said that it has to be paid by the Directorate of Education,
My lord,
not by the university, though he went lien. And secondly,
my lord.
he was not permanently absorbed in the board,
University.
that is the university.
University.
But here is a different case. Here,
My lord, we have been
the
permanent
person concerned was permanently absorbed.
absorbed.
So he
My
he
lord,
became a member of the, or an employee of the board, of the council
my
rather.
lord.
So that is the reason.
My lord, besides all the applications of the law, my lord, it is an admitted position that I have rendered my service more than 37 years in the higher education department, my lord.
No,
So,
thing is this,
my
now, to consider your case for such benefit of pension from Director of Higher Education will not come because you are already absorbed as a permanent employee of the,
SEBA, my lord. That is correct.
and
my
that
lord.
is why, since you are permanently employed in SEBA,
My lord.
which are not having that kind of benefit from
SEBA.
exactly. And as been shown by Mr. Gogoi, the provisions of Rule 98,
Pro rata, my lord.
then pro rata that amount that was deposited, the
I have returned back, my lord, deposited claim.
which has to be forwarded to the
SEBA,
board,
my lord.
right?
But my lord, may kindly appreciate, my lord, the by this way or that way, my lord, I am entitled to a regular pension, my lord.
See, basically, one thing we cannot, is there any rules of you regarding pension?
My lord,
Any rules of you?
yes,
follow
we have statutory rules, my lord.
Just give it to us.
SEBA has the statutory rules, lordship kindly see. Page 114. Pension. 6 clause 2, my lord, lordship kindly see. Every employee, including employees in the tenure post, should have put a minimum of 10 years of qualifying service to be eligible for pension, subject to such regulation as may be applicable to the categories of pension set out below. Next, lordship kindly see 6 clause 6. Superannuation or retiring pension. A superannuation or retiring pension shall be granted to an employee who is entitled or compelled by rule to retire from service at a particular age. That is after 60 years, superannuation. And next to my lord, FR 56B, government service in the public interest may be given compulsory retirement by giving 3 months notice so and so, and pay allowances of leave of the notice so and so. And next, lordship kindly see 6(8), clause 8. Page 115, clause 6. Qualifying service for receiving full superannuation shall be 25 years instead of present 32 years. Proportionate pension shall be given to those employees who have contemplated minimum 26 monthly periods. 26 monthly periods, that means 10 years of qualifying service, but less than 56 monthly periods of qualifying service, that is 25 years. Those who have complete 10 years and not complete 25 years, he or she will get the proportionate pension. And those, Lordship kindly see, the petitioner, in case, my lord, petitioner, he has not completed 10 years of qualifying service to eligible for the pension. That is the, my lord, facts. Now he completed in the SEBA 7 years, 2 months. Now I will come to, my lord, this is our rules, the statutory rules, my lord. I will come to statutory, my lord, Lordship kindly see the Assam Service Pension Rule 1969. My friend Mr. Gogoi referred 98. I'm reading it, my lord. Retiring pension. 90th governor may, at his discretion, allow a government servant in superior service proportionate pension or such other retirement benefits as may be determined on his resignation from government service, being accepted for accepting an employment or continuing in employment permanently under a body corporate owned and controlled by the government. Lordship policy note 1. Lordship, has you got this book, my lord? In case of government servant,
Just a minute.
both employees are not government servant.
You have brought in this
Note 1.
pensionary provision since when?
Yes.
Since when you have been bringing the, because earlier pension was not there in the SEBA.
Earlier, old book is, my lord, I have not brought it, my lord.
Since when the SEBA introduced the pension scheme?
Prior to 16, my lord, 2016, what happened? Some amendment is incorporated and it is printed in a one book. Otherwise, single regulation, single book was there. Now it is clubbed together, 5 or 6 regulation is all together in 2016. It is wrong, it should not be 2016, but it should be the year of that earlier regulation. However, our regulation is continuing, my lord, pension. Now, what I am pointing out, Lordship, kindly see, note 98, note 1. In case of government servant who is deputed or transferred to service under a body corporate owned and controlled by the government, this is not applicable because it is this clause is not applicable in case of this petitioner's husband, because he was working in the Prajudice College and thereafter by virtue of the advertisement, direct recruitment, he was participated and selected and appointed. He was not transferred and deputed, though he was on lien. After extension of 1 year lien, my lord, he was released from the college with effect from 1998. That means he is released. And so far is concerned, my lord, petitioner, he did, this clause is not applicable, my lord. Note 1 says, specifically said, in case of government servant, the board servant is not an employee of the board, but it is not government servant. Different is, my lord. Who is deputed or transferred. These two are not applicable, my lord. He is not deputed. He is not transferred. He joined in the SEBA pursuant to the advertisement by direct recruitment. So I will come to the one, my lord, case law, my lord, kindly see. I will clarify all these things, my lord. How he is not entitled. My lord, this MR Prabhakaran case, my lord, 2012, 9 SCC 671. MR Prabhakaran. Lordship, kindly see last, this is yes, para 19. Others are there, my lord, I will come to the later on. Just I want to show, my lord, 19. We may point out in Sil Kumar Jain, Supra, that this court was dealing with an insurance scheme and not pension scheme, which is applicable in the banking sector. The provisions of both the scheme and the regulation are not part perimeteria. In Sil Kumar Jain case, while referring to para 5, this court came to the conclusion that the same does not make distinction between resignation and voluntary retirement. The only it only provides that an employee who wants to leave or discontinue his service amounts to resignation or voluntary. What is resignation, my lord? I am saying, though there is no, my lord, application submitted for resignation, my lord, he discontinued his service. When he not inclined to go to the earlier department, due to college, and discontinue his service amounts to resignation. If that is amount to resignation, lordship, kindly see. Kindly see next case, my lord. Next case is, my lord, 2015-11 SCC 199. This is, my lord, estate of Madhya Pradesh and Hitikishore Goswami. Hitkishore Goswami. My lord, kindly see, state where, my lord, come to the facts, my lord. Paragraph 9. The respondent then applied for assessing his pension and payment of gratuity to the concerned authorities. The column 7 of the form mentioning that the beginning of the service 3rd January 1966. However, later the respondent joined in issue with the state that while calculating his pensionary benefits, the past service of his past period of his service, which he rendered as a lecturer in the government schools from 2nd July 1963 to 1st of January 1966 should also be counted. My case is, my lord, he was in a earlier one secondary education. In my lord, up to, my lord, 2nd July 1963, and thereafter he resigned it and joined another college, my lord, college on 1st of, my lord, resigned from 2nd of January 66. He said this past service should be counted. And this Supreme Court says, my lord, gave rise to the filing of a writ petition. The respondent asked the state for determination of the question as to whether he was entitled to take benefit of his past service from 2nd July 66 to 1st of January 1966, so as to include the said period in his total length of service for counting qualifying service to fix his pension and other retired benefit payable to him. The state contested the respondent writ petition 2 grounds. State where I will come, my lord. 13, 14, my lord. Kindly see. Learned counsel for the appellant state, while assailing the legality and correctness of the impugned order, reiterated the same grounds as were urged before the courts below and made twofold submission. In the first place, they contended that the courts below are in entertaining and eventually allowing the respondents the writ petitioner by issuing the impugned direction. It was his submission that once the respondent voluntarily tendered his resignation from his earlier service, which on his acceptance enabled him to join the new service as a lecturer in the government degree college, the period spent in the past service was not available for being counted, nor it could be part of the qualifying service while fixing his pension. In other words, the submission was that acceptance of respondent's resignation by the state resulted in severance of his relationship with the state so far as that the particular service or employment was concerned because it brought to an end the said service and employment for all purposes, because there is separation, cut off his relation after resignation. But resignation and then retirement is different thing. Resignation, today is appointed, tomorrow I can resign it. But retirement, there is a nexus with the employer and employee due to for pension like that. It was for this reason, the learned counsel for the state asked that the period spent in the service which was not available to the respondent while counting the qualifying service for fixing his pension. This submission asked by the learned counsel was not decided by the court in its proper perspective. His second submission was that when the respondent himself mentioned in the pension form that his date of beginning of the service assessing from 3rd of January 1966, then in such circumstances, he had no right to turn down and request the state to count his past service rendered prior to 3rd of January 1966. And Lordship then 16 paragraph. Next page. Having heard the learned counsel for the parties and perusal of the record of the case, we find forth in the submission of the learned counsel for the state. In our ordered considered opinion, the respondent was not entitled to claim the benefit of his past service, which he rendered from 22nd July to 63 to 2nd of January 66 as lecturer in the government school while determining his qualifying service or fixing his pension, etc. It was for the reason that respondent having voluntarily tendered his resignation from the said service without there being any condition, much less a condition to enable him to claim any kind of its benefit in the event of his joining other services with the state. No benefit of such past service was available to the respondent. And 19, in our considered opinion, the effect of tendering resignation by the respondent may be for any reason was not the relationship between the parties insofar as that particular employment was concerned, got severed for all purposes, having no benefit to remain in the respondent's favor. It had no connections with the respondent's subsequent employment, which began 3rd of January 1966. In order to claim continuing in the service for claiming any benefit arising therefrom, it was necessary for the respondent to have shown any specific rule or condition recognizing such right in his favor. The respondent, however, was not able to show any such rule or condition in favor. Paragraph 21. It is a trite law that the right to claim pension is governed by the statute. An employee has, however, no right to claim any benefit in relation to pension, deals the statute. Now, my regulation is a statute rules, my lord. So, pension only can claim any employee under the statute. He has a right. And paragraph 24, lordship. In the light of the foregoing discussion, we have the considered opinion that the courts below are in directing the state to give benefit of the respondent of his service, which he had rendered from 2nd July 1966 to 2nd January 1966 for fixing his pension without properly examining the effect of tendering resignation on the issue in a repetition. In our opinion, the respondent was therefore entitled to get the benefit of his service rendered from 3rd January 1966 onwards as mentioned by him in the form so and so, so and so. And paragraph 27, in view of the foregoing discussion, we allow the appeal, set aside the impugned judgment and orders and consequently dismiss the writ petition filed by the respondent. So this case is clear, my lord. What is his relation with the SEBA? Direct recruitment, he's come to the SEBA. And his relation with the prosecutor's college already, my lord, severed, cut off when he resigned. Therefore, his past service from 1964 to 1995 cannot be counted for the benefit of the pension in the SEBA office. SEBA cannot count it. This is not applicable, my lord. These are the important case, my lord. His relation severed. And next case is, my lordship, kindly see the 2014 13 SCC 485, the Punjab National Bank. Lordship, kindly see. From the huh? Huh?
Yes.
Yes, lordship, kindly see. Lordship, kindly straightway go to the paragraph 4. As on that voluntary retirement of the respondent had not completed 15 years of service. In fact, service rendered by him as on that was 14 years, 2 months and 19 days. For this reason, the appellant bank did not issue any pension order in his favor. The respondent, however, pleaded that since his application for voluntary retirement under VRS 2000 was accepted, which lays down the conditions of service for a minimum period of 15 years, the respondent became entitled to pension as well as in much as the deficit period was waived by the appellant bank by its conduct and accepting the application for voluntary retirement. As a representation of the respondent to grant him pensionary benefit was rejected by the appellant bank, agreed by the order of the rejection, the respondent filed civil suit in the Court of Civil Judge Gurdaspur, Punjab, for declaration that he was entitled to pension with consequential relief and for a mandatory injunction to direct the appellant bank to release all the benefits along with interest at a rate of 18% from the date from becoming due to him. The suit was, however, dismissed by the civil court by judgment in decree 29/8/2003, holding that pension could be granted only on completion of 15 years of service, which period of service the respondent had not completed. He was therefore held entitled to other benefits like as so and so, so and so. still agreed, the respondent took the matter to the High Court for Punjab. This actually matter only because he did not complete the 15 years that he is not entitled. Court has held that he is not entitled for pension because he completed all 14 years, 9 months something. This is the case. And manner, our regulation is clear. Board's regulation, it is made under the 1961 Second Education Act, Section 24. That's why it is statutory. Supreme Court says regulation, my lord, kindly see 114. I have already, my lord, mentioned it, my lord. Qualifying service to be, my lord, 25 years to get full superannuation pension, and qualifying service to get pension 10 years minimum. If he rendered service less than 10 years, he is not entitled for any pension. However, in the petitioner's case, my lord, on frequent request, on sympathetic ground, SEBA has given a pro rata pension to the petitioners. So that is the case. So in my humble submission before Lordship, I want to point out one letter, my lord, from the writ petition. So that problem can be solved by the Director of Higher Education, Secretary, Principal Secretary. Good. Yes, page 44, Lordship. This letter is issued by the Director of Higher Education to the Principal Secretary Government of Assam regarding pension of late B.C. Goswami, retired controller examination. With reference to the subject cited above, I have the honor to inform you that late B.S. Chandra Goswami serves as election at Pragyatis College with effect from 5/8/1964 to 3rd of January 1995 for a period of 30 years, 4 months, 29 days, and served in SEBA as controller with effect from 95 up to the date of retirement 31st March 2002 for a period of 7 years, 2 months, 28 days, and subsequently expired on 23rd November 2007. As per SEBA's pension rule 3, minimum 10 years of service is required for granting pension. But considering the hardship faced by the Mrs. Ashola Goswami, wife of B.C. Goswami, SEBA has decided to provide pension, family pension on pro rata basis to Ashola Goswami, the petitioner, for the period of service rendered by her husband B.C. Goswami in SEBA. Now, Mr. Goswami has requested to make necessary arrangement for pension, family pension against the period of service rendered in Pragyatis College. So, in this connection, it may be stated here that GB of Pragyatis College had allowed lien to let B.C. Goswami up to 21st April 1998 and released with retrospective effect with effect from 27/1/1998. He did not resume service at Pragyatis College. So it is clear that ex-lecturer's lien on the post held by him was terminated, violating FR 14A. It is also not clear whether transits of the late Goswami from Pragyatis College to SEBA had the approval of DAC or government. It is not clear whether actually he did not get the approval from the higher education. He did not apply proportional. As per Gov of India's instruction below, FR 14A, FRSR, in all cases, the government servant is to be absorbed permanently by the foreign employer under his organization. It would be incumbent on him to consult the parent employer before issuing orders absorbing the government servant. The order of permanent absorption should be issued only after resignation of the government servant has been accepted by the government. Regarding government servant, my lord. Moreover, as per Assam College Employees Provincialization Act 2005, under Section 8, the employees who retired, died prior to 1 month 2005 shall be given superannuation, family pension subject to refund government state of CPF money within 31st May 2006. As per Section 8A, the Assam College Employees Provincialization Amendment Act 2010, the date of refund government share CPF money has been extended up to 10/11/2010. but neither Let Goswami nor his family member has refunded the gov share of CPF money within the stipulated time. Hence, family pension to the spouse of the BC could not be considered as per Assam College Provincial Rules Act 2005 till death. However, government is requested to take appropriate action for providing pension, family pension to Mrs. Osola Goswami against the period of service rendered by her husband, so in the practice. So this letter specifically requested the government. You consider it because he rendered service more than 30 years. So he considered it only hardly is because as per provisions of the College Employees Provincial Amendment Rule 2010, he was to opt in. He was to have option whether he will accept the pension or whether he will accept the continue the CPF. That is the problem only. This hurdle can be easily removed by the government. Because the governor has also, I have seen in the pension rules, but governor has a discretion power to grant pension, proportional pension to a government employee. This letter is not acted by the government. If it is acted, there is no problem for the petitioner, my lord. He would not have come to the court. These are the problem, my lord. Next 46, Lordship Kalisi, this is our order. Order in pursuance of the decision of the board meeting. Huh?
Just a minute, just a minute.
Itu 66 calculation itu effect of tender administration as common growth prepare for all purposes having no benefit to the manager.
Yes.
Yes, Lordship, this letter, this copy was issued to the chairman, Seva, and also the petitioner. So this letter says, my lord, this is only a small hurdle on Lordship 46 page. Page 46 our order, my lord. 23rd July 2018. In pursuance of the decision of the board meeting held on so and so, resolution so the pro rata pension is granted in respect of Sri B. Goswami, retired controller of exams, who had rendered 7 years, 2 months service in the board of secondary education Assam. Further, the pro rata pension will be continued till the death of the incumbent up to 23rd November 2005. So we have given. And that is, my lord, that is petitioner accepted, and copy given to the petitioner. Petitioner accepted lordship there, my lord, in the records. She accepted the pro rata, and she has my lord, she has, my lord, given thanks to the Sabha for this sympathetic consideration, and requested the Sabha also to request to the higher education so that she can get the family pension. That is the question, madam. She has already accepted. Now she cannot see, petitioner cannot deny it that I have not received. And she has given a willingness letter, whether we accept or not. She has accepted. And now what is the liabilities on the part of the board? Sabha has no liabilities, madam. We have given, and a person who those who are working more than 30 years in the one institution, and another is 7 years. And who is one, from which institution the person retired will get the pension or any service benefit? Definitely under college, another higher education. On the above facts and circumstances, my humble submission before lordships, the petitioner is not entitled to any pension benefit from the SEBA. After getting this also, pro rata pension by the petitioner. That is my submission, my lord.
Yes. Now, lordship. Both of us. So, lordship, just I clarify from I taking the last submission made by my senior lordship. Then, lordship, the service concept of service jurisprudence would be changed, lordship. If that view we have to take in, lordship, the persons who have the length of service, if we determine the pension, lordship, regarding the length of service, then, lordship, new service jurisprudence will be come up, lordship. Where pension have to get, lordship. Pension have to get from the persons from where he is retired finally, lordship. Not from originally parent department which is lordship. Then service concept of service jurisprudence will be changed, lordship. Now, my lord may kindly peruse page 39 for a moment, lordship. Page 39 of the repetition, lordship. It is a view of the PPG, lordship. And before that, lordship, the letter is page 38, lordship, which was issued by the joint secretary to the secretary to the SEBA, lordship, whereby she has forwarded the view of the PPG, lordship. That is in page 39, lordship. Your endorsement, so and so, lordship. Pension and Public Grievances Department, after careful examination of the fact, observed that late B.S. Chandra Goswami had initially rendered service as a lecturer in the Pragjyotish College. Thereafter, he had technically resigned from the college. My lord may kindly mark it. He had technically resigned from the college and to join SEBA permanently and retired from the said organization as a controller of examination. Then, lordship, it has further observed that both the services mentioned above rendered by him does not fall under the purview of the Assam Service Pension Rules 1969, for which the department could not count his past service as well as offer any views for refund of the gov share of the CPF as sought for, lordship. Then, lordship, however, Education Department may take up the matter with SEBA. My lord may kindly mark that paragraph for a decision regarding depositing of CPF amount and counting of past college service of the deceased employee as per the existing rules and act of SEBA, lordship, for extending family pension and other benefits to the legal heir, wife of the late so and so, controller of examination, lordship. As because, lordship, there is a pension rules is there, lordship, SEBA. So the PPG's view is that the prescription prescribed in the 1969 rule is not applicable here. So the independent decision has been taken by the authority on the basis of the pensions rule SEBA by counting the past service, lordship. Then, my lord may kindly come to another page, lordship, page 22.
24.
Page 22, lordship, 22, lordship, 3. The submission of the lordship, my senior friend is lordship, time and again reiterated that he is a direct equity lordship. If he is a direct equity lordship, then how lordship that copy to number 3 is lordship come up lordship. The principal Pragjyotish College Guwahati for information and necessary action with reference to his letter dated so and so is requested to send the service book of C so and so and amount of the CPF due lordship. My lord may kindly mark it. To him to the undersigned with a detailed account of it lordship.
Just a minute. Yes.
Again, I reiterated lordship. He is requested to send the service book of C so and so and the amount of CPF due to him to the undersigned with a detailed account of it lordship. And his request is us also for the return of the CPF amount also lordship. That signifies that indication is that lordship, his past service was already taken into consideration lordship. And under the lordship 1969 lordship, already my lord has already perused rule 98 lordship. And as per section 4.2 of the 1961 Act lordship, the burden shift to lordship Seva lordship. He is no more an employee of us lordship, and his lien was lordship terminated in 1998, and he is permanently absorbed that particular board lordship, and our liabilities only that part is there lordship. The return of CPF amount is extended till today by way of amendment lordship. In 2020 amendment also there lordship. Accordingly, petitioners has lordship refunded that amount in the husband's lordship contribution lordship. And now our duty is lordship, we have to send it to the Seva lordship for prorata pension part lordship without enclosing interest part and leave engagement, everything lordship we have to send it. This is that part we have to do lordship. After that, Seva has to lordship give whether they have count their past service by applying their principles lordship, it is up to them lordship. And PCG's view was also lordship clear lordship. And Act also says that lordship. And regarding condonation part lordship, they can do lordship. And regarding letters, page 44 lordship. That letter is not a lordship, final decision of the government lordship. And by written a letter by a particular officer, that does not signify that we are violating the statutory prescription lordship. We have to go by the prescription prescribed by the statute lordship. This is my humble submission before your lordship. I would call.
My lord, what transfers, my lord, from the submission of both the respondents, my lord, that there is a fight and tussle going on, my lord, between both the SEBA as well as the higher.
No fight. No,
my lord, they are shifting the burdens, my lord, from here and there, my lord. So, but it is not a case, my lord, that they are not denying that I am not entitled to my lord rights of pension, that is the family pension and other benefits, my lord. Now, my lord, may kindly, my lord, taken into account that my past service in the college, my lord, of more than 30 years, and if I count the rest part in SEBA, my lord, that is 7 years. It is almost, my lord, 37 years, 4 months of service I have rendered as a, my lord, ultimately as a government employee, my lord. Although for the initial time, it was not provincialized, but later on by virtue of, my lord, 2005 Act, these employees have been treated to be as a provincialized employees, my lord. Now, although I left the institution, my lord, in the year, my lord, 1995, but thereafter the provision has been made, my lord, for the purpose of provincialization. Now, my lord, a person who, my husband, my lord, who served more than 37 years of service as a government employee, my lord, now I am going to deprived of from the benefit of this, my lord, pension, regular pension under the 1969 rules, my lord. My lord, it is admitted that the SEBA is maintaining a separate regulation, my lord. That is the 10 years and maximum for the full pension, 25 years is required. My lord, if I club both the service period of 30 years and 7 years, my lord, come down to, my lord, more than 25 years. Now that past service, my lord, it cannot be wiped out, my lord, especially for the purpose of pension, my lord. And, my lord, the various communications, my lord, which my respected senior friend as well as my learned friend has, my lord, reiterated from my petition, my lord, it is very clear, my lord, that what is the stand of the government as well as the higher education department. One letter is very important, my lord, which my respected senior friend has already brought into your lordship's kind notice, that letter dated 44, my lord. The issue has been, my lord, stand to the government. However, government is requested to take appropriate action for providing the pension and family pension to so and so against the period of service rendered by so and so in Pragjyotish College, Guwahati. Now, my lord, the government thereafter has not taken this letter into account, and neither they have accepted or nor rejected, my lord. This is
See,
the letter,
basically,
my lord.
when the petitioner's husband was serving as a lecturer,
my lord,
and the period in which petitioner's husband served in the board,
yes, my lord.
question of providing any pension was not there. It was only contributory.
That is correct, my lord. That is 2005,
So
2005 act.
question of pension came up after that entire thing propped up, after the retirement of the husband of the petitioner.
That is correct, my lord. That is correct.
So the husband of the petitioner, when he approached the board,
my lord,
all along, he was insisting for fixing of his pay scale as what he was receiving in the
Pragjyotish College. Pay protection, my lord.
So he was saying that in addition to this, I was also entitled for this in the college. I am entitled for this. This
My
was going on in that
my
manner.
lord, my lord.
And he retired. During this period, during the period while he was serving at under the board as its controller, there is no instances that he has contributed something for the CPF amount.
In the college, my lord.
Not in the college. In
the board, my lord.
board.
My lord.
There is no instances.
No, there is no, and my lord, admittedly, my
Right.
lord, I have to
Now,
my lord.
since there was no pension scheme
My lord.
under the board, the period in which the petitioner's husband served, and he did not contribute anything.
My lord.
Similarly, while he was serving the college, since there was no pension scheme,
that is correct, my lord.
He deposited a particular amount till
21.
that period he served in the college. Of course, whether he took lien or whether he came with this, there is no clearance at all.
No, it was initially for lien, my lord.
It was ultimately there was some approval because the governing body of the college might have approved
that at that
allowing
period,
him
my
to
lord.
join the.
My lord.
But he accepted his service as a permanent employee of the board because after serving for 2 years,
Confirmation is there.
confirmation is then he
Mal.
accepted as a permanent employee. Now, once he has become permanent employee of the board, and there was no pensionary scheme in the colleges, government did college,
Mal.
it was on the CPF amount. He stopped contributing his fund because he is serving here.
Mal.
And then, if you see in that manner, he was cut off from the college,
From
his
94.
service, because whatever he served for 7 years or whatever till his retirement. And if you see the advertisement, it was not less than 40 years, not above 55.
Age, my lord.
And at that point of time, the retirement was 58 years.
Mal.
Mr. Sutia, it was 55 years or 58 years?
Which one?
During the time when the petitioner's husband joined the service?
95.
Earlier,
95.
when it was Mr. Gogoi, just get the information from which. We know when it was enhanced from 55 to 58. Not in 2000. Sometimes later part of it was 80 something.
2 years, 3 years, yeah.
Before provincialized.
Before.
It was initially for 59 years, 58 to 59 years, and then 59 to 60. But there was prior to that, before making 58, there was 55 years. The old pension scheme was of 1950, because the reason here is The advertisement it was there was between 40 years to 55 years. If it is 40 years to 55 years, somebody is 50 years also, will not able to complete 10 years of service.
No.
Because that point of time it was retirement was 58 years. Right?
We don't,
So-
60 years, my lord, 40 years to 60 years. At that point, only his age should be at entry to the SEBA, 40 minimum and 55 highest. Then he can, he's 40 years, then he will render 20 years up to 60 years.
You will not have to have rendered because at that point of time, the advertisement that was issued was not 60 years. It was either 58 years or it was 55 years.
More than advertised time, yes. Advertised time, my lord, is actually I don't know, my lord. I cannot say.
Cannot be more than 58 years.
No, cannot be.
Cannot be.
It was not there 58, only it was 58.
My lord, another situation could have, my lord, arisen, my lord, that if I, my lord, could not join in SEBA, and if I retired on, my lord, 1994 or 1995, my lord, when I opted for lien, my lord, then what would have my situation, my lord? Then I could have get the pensionary or other benefit which are other similarly situated employees are being paid by the government after this 2005 Act came into force, my lord. And my lord, regarding the resignation part, my lord, I have not, my lord, resigned formally, my lord. It was just a technical resignation, my lord, which was there on record for the purpose of my allowing my confirmation at the, my lord, SEBA. That is another issue, my lord.
The fault of the petitioner.
No, not my fault. Husband was there. But that
Husband.
In 95 years, it was enhanced from 58 to 59. 95 years. Earlier in the year when the latest one is proceed, at the return control time 58 years.
See, one thing, Mr. Bhuya, it is very clear.
Mal.
During the 10-year service of the husband of the petitioner, he was interested only for his pay fixation. He was never interested for his past service in the Pragati's college. He never approached the board for securing his past service in the Pragati's.
Yes, never. My lord, fixation of pay, my
And
lord.
only for fixation of pay,
My lord.
he was insisting on that.
Not fixation of pay
They
because
don't,
at
see,
that-
reason is
my
very
lord.
clear because there was no pensionary benefit excepting the CPF.
My lord. My lord, at that relevant period of time, my lord, perhaps my husband, as he is no more, my lord. My lord, have.
No, see his letters, see everything if you see.
My lord.
Only that much.
My lord, pay fixation, my lord, counting the past service benefits from my Pragati's college service, my lord, is amounts to, my lord, that if they have given the pay protection, my lord, counting my past service benefits in the college, my lord, then automatically the rest benefits of my service would follow, my lord. Because they have not denied the pay protection or the pay fixation, my lord, there is a connection with my past service. Now, if the pay is fixed, my lord, with my limited understanding, my lord, what I respectfully beg to submit, my lord, that if the pay is fixed, then the, my lord, pensionary benefit is also I am entitled basing on my past service, my lord. And my learned friend, Mr. Gogoi, has already, my lord, has brought into your lordship's kind notice, which I have also, my lord, regarding that part, that asking for the service book for the purpose of, my lord, counting my past service by the SEBA, my lord. Otherwise, there is no other, any options left, my lord. To send the service book of so and so of the CPF due to him to the undersigned with a detailed account of it, my lord. But the account has also been sought for, my lord. There is a reason that the past service will be counted, my lord, at the time of confirmation order, my lord. So that's why there is a presumption or my lord that the positive thinking was there that my pensionary benefit would be counted.
Question of pensionary benefit was not there at all. The petitioner will not able to show at this stage what was the CPF amount during the lifetime of her husband he had deposited.
My lord, as the higher education has stated, my lord, that the CPF amount which is lying with this, my lord, higher education department, that can be transmitted to the SEBA, my lord. That can be transmitted to the SEBA, and whatever calculation they would like to make, my lord, they can carry out the calculation, my lord, for the purpose of benefit of pension, my lord. Or, my lord, as the letter is pending before the director, before the government, my lord, addressed by the higher education department, my lord, that letter they have also not taken any decision, my lord. What is the stage of that letter, my lord, can sought for an instruction, my lord, that what is the view of the government, my lord. If I do not get the pension, my lord, then it will be, my lord, a severe injustice would be caused, my lord, to the petitioner wife, my lord. The late husband, my lord, has rendered more than 37 years of service, my lord.
That service you are knowing fully well you have left it.
No, my lord, I have left, that is correct, my lord, but for the purpose of the, if we go by the contents of the advertisement, my lord, the advertisement was designed in such a manner that there is always a connection with the past service. Experience is counted. Now, a fresh recruitee or a fresh incumbent, my lord, who did not work as a lecturer or professor at that relevant period of time, he would not have eligible to apply, my lord, because the experience was also required, my lord, to get the job. And my lord, the my respected senior friend has said that I did not apply through proper channel, my lord. And in the advertisement, it is a condition that those who are in employment should submit the application through proper channel. Now, my lord, then they could have rejected my application at that relevant period of time that this is not fulfilling the condition. That they have not done, my lord. That means, my lord, they have accepted it as a proper channel application, my lord.
Mr. Sutia, Mr. Gogoi. Mr. Roy, you can read Assamese? Okay. You read page 51 and 52 for both of them. This is from the note sheet. You read. And Mr. Bhuya, Mr. Sutia, and Mr. Gugoi, you kindly listen.
Yes, my lord, সচিব, উপসচিব, এইটো কি বিষয়? বিষয়া অধীক্ষক, কাৰ্যালয় প্ৰাক্তন পৰীক্ষা নিয়ন্ত্ৰক শ্ৰী বীৰেশ চন্দ্ৰ গোস্বামী পাবলগীয়া অন্যান্য সুবিধাসমূহৰ ভিতৰত পেঞ্চনটো অন্যতম। সম্ভৱতঃ সচিবে অনুমোদন জনালে শ্ৰী গোস্বামীৰ পেঞ্চন বিবেচনা লোৱা নাই। লোৱা নাই দিয়া মোকলাই দিয়াৰ বাবে মুখ্য মাননীয় বিষয়াৰ যোগেদি মতামত সাপেক্ষে নিৰ্দেশ দিব পাৰে। মহোদয় জ্ঞাতৰ্থে নিৰ্দেশনাতে নথি পেছ কৰা হ'ল।
Go on reading.
Yes, my lord. Then another note, my lord. শ্ৰী বীৰেশ চন্দ্ৰ গোস্বামীয়ে পৰিষদত পৰীক্ষা নিয়ন্ত্ৰক হিচাপে যোগদান কৰিছিল 4/1/1995 চনত আৰু পৰিষদৰ পৰা অৱসৰ গ্ৰহণ কৰে 31/3/2002। তেখেতে প্ৰাগজ্যোতিষ মহাবিদ্যালয় প্ৰবক্ত পদৰ পৰা আহি পৰিষদত যোগদান কৰিছিল। তেখেতৰ পূৰ্বৰ চাকৰি পেঞ্চন পোৱা চাকৰি নাছিল। যিহেতু তেখেতৰ পৰিষদৰ চাকৰিৰ কাৰ্যকাল 10 বছৰ পূৰ্ণ হোৱা নাই, সেয়েহে পৰিষদত পেঞ্চন বিধি অনুমতি তেখেতে বোধকৰো পেঞ্চন নাপাব। Then my lord, উপৰোক্ত টোকা বিবেচনা শ্ৰী গোস্বামী পেঞ্চনৰ বিষয়টো অধ্যক্ষ মহোদয়ৰ লগত আলোচনা কৰি সিদ্ধান্ত লোৱা ভাল হ'ব। যিহেতু তেখেতৰ পূৰ্বৰ চাকৰি কৰা বিভাগটো পেঞ্চনেবল বিভাগ নহয়। আনহাতে তেখেতৰ পূৰ্বৰ চাকৰি CPF ইত্যাদি পৰিষদ জমা হোৱা তথ্য ফাইলত পোৱা নাযায়। ক্ৰমত 73 চিট পূৰ্বৰ কলেজৰ পৰা দিয়া এখন চিঠিত CPFৰ ফটোকপি পঠোৱা দেখা যায়। যদিও যদি পৰিষদে উক্ত CPF গ্ৰহণ কৰিছে তেন্তে অৱশ্যে তেখেত পেঞ্চনৰ যোগ গাণনিক ওপৰত টোকা শ্ৰী গোস্বামীৰ ক্ষেত্ৰত কোনো CPFৰ টকা পৰিষদত জমা হোৱা তথ্য পোৱা হোৱা নাই। যিহেতু শ্ৰী গোস্বামী অন্য অনুষ্ঠানৰ পৰা পৰিষদৰ প্ৰপাৰ চেনেলৰ এপ্লাই কৰি যোগদান কৰিছে, গতিকে পেঞ্চনৰ বিষয়টো অলপতে গঠন কৰি দিয়া কমিটিখনৰ জৰিয়তে চালি জাৰি চাই বিহিত ব্যৱস্থা লোৱা ভাল হ'ব।
It is not a decision, my lord. It's a note is not a decision.
So the views I am talking about, apparently that what we are discussing in this is that he did not deposit the CPF amount in this. But it is a fact that during the period while he was serving in Procedural College, he deposited the CPF amount. And he deposited up to 6/3/1995. That was forwarded by Procedural College. That is on record. There is a communication between the board and the Procedural College. And accordingly, Procedural College forwarded that the CPF amount he deposited up to 6/3/1995.
Letter is, but note said that was not sent.
Letter says, see, basically that is what we are saying. It was a letter communication from the.
I have
SEBA.
seen this letter, madam, issued by the principal principal.
Because that shows, and along with the, that we used to have passbook in the post office. That was shown that the petitioner's husband deposited CPF amount up to 6th of March. And then equivalent government share was there. Of course, that amount was not forwarded. Now, if that amount was forwarded at that point of time, got it? But yes, during the period when the petitioner served at, petitioner's husband served at board, he did not deposit any CPF. Otherwise, what would happen? That would have continued. Necessarily, he or she may go. But one thing is you have not read is that note was written to the chairman.
Internal communication, that is my.
Listen. It is very clear. গোস্বামীৰ পেঞ্চনৰ বিষয়টো অধ্যক্ষ মহোদয়ৰ লগত আলোচনা কৰি সিদ্ধান্ত লোৱা ভাল হ'ব। যিহেতু তেখেতৰ পূৰ্বৰ চাকৰিৰ পৰা বিভাগটো পেঞ্চনেবল বিভাগ নহয়। আনহাতে তেখেতৰ পূৰ্বৰ চাকৰিত CPF ইত্যাদি পৰিষদত জমা হোৱা তথ্য ফাইলত পোৱা নাযায়। ক্ৰমাংক 73 চিট পূৰ্বৰ কলেজৰ পৰা দিয়া এখন চিঠিত CPFৰ ফটোকপি পঠোৱা তথ্য দেখা যায়। যদি পৰিষদে উক্ত CPF গ্ৰহণ কৰিছে তেন্তে অৱশ্যে তেখেতে পেঞ্চনৰ যোগ্য। কাননিক শাখাৰ পৰা তথ্য বিচাৰি বিষয়টো নিষ্পত্তি কৰিব পাৰি বিবেচনা অৰ্থে। Now কাননিক শাখা প্ৰয়োজনীয় তথ্যৰ যোগান ধৰা। তাৰ পাছত I don't know whatever the account section has given, it is not there. Now letter goes to, the note goes to the commissioner, the chairman, sorry. ওপৰৰ টকা শ্ৰী গোস্বামীৰ ক্ষেত্ৰত কোনো CPFৰ টকা পৰিষদত জমা হোৱা তথ্য পোৱা হোৱা নাই। যিহেতু শ্ৰী গোস্বামীয়ে অন্য অনুষ্ঠানৰ পৰা পৰিষদৰ প্ৰপাৰ চেনেল এপ্লাই কৰি যোগদান কৰিছে। It is there. That's why I was saying. That's why I was reading the notes.
These notes written by.
What is the, we do not
This
know.
note written by which.
Gutike, see what? See, this is your record, Mr.
Yes.
Yeah. Proper channel apply কৰি যোগদান কৰিছে। গতিকে পেঞ্চনৰ বিষয়টো অলপতে গঠন কৰি দিয়া কমিটিৰ এখনৰ জৰিয়তে চালিজাৰি চাই বিহিত ব্যৱস্থা লোৱা ভাল হ'ব। And then probably it was found that oh, that man has retired. Now let us play the game. But should have, in fact, that particular passbook should have been sent to the board, and board should have continued with this CPF amount, right? And then neither the husband of the petitioner was looking after it. He did not ask for pension. He was much more aware, was much good thing after fixing his salary. He did not ask for it. Only after his retirement, he started taking for his pensionable. But during his tenure in SEBA, he never asked for his pension. He never asked for depositing anything.
Because he knew that he will not complete 10 years.
Well, while going through your rules, the SEBA rules, regulation on retirement benefit pension of the board 2016, there was no rules as such prior to 2016?
Yes, there was an earlier rule was there.
What was that rule? Do you have a rule regarding pension? Any other rule?
Earlier, there was a rules one.
Can you give it to us?
These books are printed in 2016. That's why they have written all these things, regulation 1616.
Okay.
Wrong. I discussed it with the secretary. They say it is wrong. Now, earlier, board regulation for appointment and service condition was 1989. Now, this has been 2016.
Can you give us that rule?
Printing mistake.
Can you give us that rule? This should be read as 1989 or 2016.
89, Manoj.
But you had the pension policy in 1989.
I will have to check up it regarding pension member. But regarding appointment and selection appointment and also service condition of the employee, that was 1989. I remember it. Correctly.
Yes.
2002 he retired.
No, if there is any such provision in the 1989.
89, Manoj, I will check up, Manoj. No, no. So during that period, his service was not considerable in the several.
Because these 2016 rules, if you read as 1989 rules, it also provides for relaxation.
Relaxation clause is there. That's why, Manoj,
considering that period and the amount of CPF amount that has already been deposited with the government treasury, with the approval from the principal of the Pragjyotish College.
by relaxing the rules, Manoj, Purata pension has been.
She will get for family pension. She will get family pension. The prorata pension was given to her husband. The thing is that leaving aside everything, she will be entitled for family.
Until the CPF amount, Manoj, received by the college.
That is lying with the government.
Yes.
That is lying with the government. That will be sent.
Until that has been received by the board, my lord.
So at least she will get family pension. Whatever the benefit given to her husband, that is different. But relaxity got, she will get the family.
Because 2019, 2002, and mostly there is an amount of interest accumulated in the government treasury. They enjoy it,
Now
but
just tell us one more issue. Mr. Gogoi and Mr. Sutia, one thing you have to clarify. Now, no contribution from the side of the husband of the petitioner during his lifetime. If we have to see that to be given her the benefit of family pension, it will accrue on the amount that is lying with the government.
And they have also 50%, they have deposited, amounting to 78,000.
Where from you are saying that they have deposited? No. See, it is CPF means both A and B together, right?
Only government. Government share.
So that share she has deposited. Now that's fine. But what about the? Right. There is nil. So if the considering that aspect the amount, if any family pension is to be given, on what basis? No, because it has to come on the that position. Only 78,000 or something that has been deposited.
It has been deposited hours. There is no contribution.
My lord, total CPF was counted as 1,57,288. And out of that, my lord, 50% I have already deposited. My lord, may kindly turn to last page, after 49, my lord. Written here, my lord. referred 50% from share of CPF money with the interest to the government of Assam, DHE letter so and so dated so and so. The incumbent opted for pension with effect from letter number so and so. Total CPF amount is so and so, 50% of which is rupees so and so. And which I have deposited, my lord, write this challan at page 50, my lord. Rest can be, my lord, calculated, and if it is required, my lord, that can be adjusted also, my lord.
Where from you got the amount is total CPF amount is 1,57,000. No, that's the type copy of the Salan.
As per the instruction of the college, my lord. Principal project is sign is here.
Next page. See that page and the next page. It was forwarded by college. If you turn to the next page, you will see only the deposit made by the husband of the petitioner. There was no government share. Government share was not there. So normally what happens, the government always gives that share only at the time of retirement. They are not, it is not that only, it is the requirement of the incumbent to deposit regularly. And the government share comes suddenly at the time of retirement. So maybe after calculating this amount, this 1,57,000 was with the government share. Otherwise, we have seen in other cases also. It is the only at the time of retirement, if CPF amount, they will not deposit and they'll calculate and give it together. So that is why they are asking in 6 months' time prior to depositing all this. That is the procedure they used to follow. They were required to give every month. They are not doing it. Anyway, so that is why you will see up to 6th of March 1995, the husband of the petitioner's deposit is there. He has deposited his. Hereafter, it is not. Okay. Only thing is on which amount the petitioner will get her family pension. Even if we direct the government to. There was no contribution. There was no contribution from the part of the.
Yes, there is no contribution from husband's part in the time of survival. The contribution is nil.
Account here নাই কিন্তু কলেজৰ contribution খিনি যেতিয়া পাই লৈ লৈছে ন এতিয়া নহয় জানো ৰেকৰ্ড আহিলে মানে মৰিল মানে আমি নাভাবা বস্তুটো তেওঁ বিচাৰি ওলাই দিব.
Yes, Mr. Sutia.
Well, it is so far note is concerned, my lord. This is not a decision. The Supreme Court says.
And that is why matter was placed before the committee to decide.
Yes. Then
See,
whether committee has decided, whether committee has taken a decision or not, that is the.
They are also aware of the fact what had happened basically.
So let the amount contributed by the petitioner and also government share be sent to the SEBA. SEBA would decide it. Otherwise, he is not
It was
eligible.
deposited in 2020, right?
21 million.
21.
Okay.
We have to return with the interest With interest. Third,
Lord deposited on 12/1/21.
yeah, well, and council for the interest. Mr. T.C. Sutia, assisted by Mr. K. Roy. For the, no, Paragote later. Mr. K. Go Western Council had education to the numbers 1, 2. Any government advocate here? Yeah, because pension department is there. Okay. During the part. Notice not served on response number 5,
Just served, my lord.
not appeared.
Yes, my lord. Service was complete, my lord. I have checked.
Here. Standing council. Have a- What respondent numbers? Respondent number 4. Any of the note? The notice on the response number 5, college to the list of the said respondent number 5 is not appeared. Order it.
Obliged, my lord. Highly obliged.
Oh. कितना कौन है मेरा टुकन तो है टुकन तो पहले particular 8 connect particular 3 open 8 connect 92 Mundal, what is the urgency in your case?
Since 2021, we are not getting salary because of some interim order passed by the Honorable Court. Now record has come, my lord. My friend will produce the record, my lord. Matter is, my lord, very short, my lord. 41 and 40.
Lord, here in these three cases, in item number 40, my lord, I am for respondent number 9.
Okay.
And in other two cases, my lord, I am the petitioner. Sir.
Okay. In the second item 41, you are the petitioner.
Yes, my lord. Sheikh Mehboob Alam 1949. My lord. The matter is the same matter, my lord. Same matter involved. Same school, same service. But may I request your lordship to take 41?
Yes, madam, you are appearing for the education. Now just tell us what happened after 22nd of November 2022.
May I point out one thing, Malad?
We'll come back to you. We'll come back. What happened after November 2020? One of the member of the SLSC retired. Then whether the SLSC member has been nominated or at the state level at the same stage. Are you aware of the fact?
The last statement we are directed to take the original copy of the application case.
Do you have the entire records with you?
Only the copy of the KCN and
The report that the director received from the SEBA, that when the director did not send you the entire records. Just a minute. Just a minute.
we are directed to take the original records of the KCN and
True. But read it and tell us.
that report is not accepted. But I have the copy of my taxes, GST.
Earlier, the director communicated to the court on 15/11/2022. On 31st of October 2022,
I will be taken next week, but I will take the
not next week, tomorrow. Get whatever is there. We have seen that on 31st of October 2022, the SSA authorities submitted a detailed report as per DICE and UDICE database. It was available with the Director of Elementary Education Assam. And the director did not place the matter, did not place that particular report received from the SSA. It is here in this letter. It was issued on 15/11/2022. Clearly stated. No receipt, but in the meantime, one Rita Borborua, Joint Secretary, Government of Assam Independent School, and member of the SLSA, retired. Where is that report? It was available with the Director of Elementary Education Assam. What is the need of hiding it? Why in your record that report is not available? Place it tomorrow at 10:30. Give us that communication. say no point of hiding documents with the court. Department will have different thing, mind that, particularly from this court. Don't hide. No hide and seek game. There might be a default because it is clear that the report forwarded in the paper format or the document format and as the email format are different. That is the finding you have just read. That is why the record has been called for. Also, Brother Buzarbura has passed a specific order. Why the respondents have made such statements that it is not available, it was available. I don't know, we have not seen the records whether the respondents have filed any affidavit to that extent or not, complying with the order of the court. But when the director of the elementary education, being the chairman of the state level scrutiny committee, having those materials from the SSA, DICE and UDICE, why it is not placed before the
Last of the original
on
record from the
22nd
director was
November, one
produced.
letter, 15th of November, 2022, the second letter, 22nd of November. What is there in the DICE code? In the DICE code that was been forwarded by the SSA, it should have been placed, place it tomorrow at 10:30. Let it, bro. Not to, we do not know what will be back to at 10:30.
Earlier, original record from the director office was produced before this honorable court.
We'll see to that, Mr. Mantu, tomorrow. Place tomorrow at 10:30. The respondent, Director of Elementary Education, Assam, self-placed the 11 records in the original that it received from the SSA Assam by communication dated 31/10/2022, which is also reflected in the letter of the Director of Elementary Assam dated 15/11/2022 and 22/11/2022, placed before the court earlier.
Lordship, this is J. Pang was there, but due to some circumstances, he left the court. May this matter come up on Monday.
Matter relates to my the filling of the post of assistant professor in the Silabata College.
Hey, Burua. Data, please take it. No, speaking of it. Who took the hearing?
Director took the hearing, my lord, but the calculation of mark was done by his OSD, man.
That is a different possible, but the hearing was conducted by the director.
Yes, ma'am. In his presence, the hearing is conducted.
Because the director may allot the about the marks and it may be placed before the authority. Had it been heard by that authority and reported, the report is to be submitted, it would have been different.
But, my lord, the manner in which the marks were allotted, it is contrary to the guidelines, my lord. And only academic marks have been considered, my lord. The marks we received against our academic record, only those were taken into consideration, my lord.
For the order of the court, there is an application before the Director of Higher Education, which your grievances.
My lord will find this at page At page 41.
Your,
Read it.
your representation
Yes, my lord.
after the order of the court.
Yes, my lord.
What is your grievances therein?
My lord, my grievance.
The direction was very clear.
Yes, my lord.
Detailed representation before the Director of Higher Education.
Yes, my lord.
Taking all the grounds and also enclosing a copy of the writ petition. Anyway, where is your application?
At page 41, Lord, you will find it.
Yes.
And starts at page 43. At paragraph 23 of my writ petition, my lord, I have narrated my grievance, my lord, which way before the director, my lord.
Now, as per that office memorandum, 8/11/2018, where you have annexed
106, my lord. And 108 is the relevant portion.
Yes.
At page 108, Lordship will find the distribution of marks.
Yes.
Marks are there, my lord. Begins PhD, 9 marks, MPhil, 3 marks, research paper article in concerned subject domain published in journal research book, 2 marks, research paper in the concerned subject domain published in the factor journal existing data scopus, 4 marks have been allotted. Number 5, 1 mark each per chapter article in the concerned subject published in research textbook with ISBN subject to maximum 2 marks.
Okay.
In case
These
of
are the distribution of marks.
distribution of marks.
Then How they have calculated?
And my lord, kindly turn to page 178.
Yes.
177 last para, my lord.
Hmm.
However, may I read, my lord? Last para. However, publication of MS Deepika Borua as submitted in the aforesaid hearings are eligible for consideration as the journal was Scopus Index till 2019-20. But since his second author in volume 7, issue 4, she may be awarded 70% marks. And she was the third author in the publication volume 7, issue 6. She may be awarded 30% of marks. Total, she may be awarded 1.4 plus 0.62 marks. That 70% and 30% is absolutely not in conformity with the office memorandum, my lord. And my lord, the next para of page 177, 178, that lordship will find the marks in the bold letters, 57.3 marks and 52.18 marks. These are the marks awarded to the petitioner and the private respondent for their academic qualification, my lord. Overall marks has not been considered in this order.
Is it required to be considered?
As per this honorable court order, my lord, the entire record has to be considered. If lordship.
This is in terms of anything, any marks to be considered has to be in terms of this OM.
Yes, my lord.
There cannot be any other thing.
Yes, my lord.
Now, as per this OM, you are saying that it is Scopus and this assessment. So according to you, since your publication was there, whether it is fourth volume or seventh volume or third writer or fourth writer,
Yes, my lord.
it should have been considered
Yes, my lord.
two each.
Yes, my lord.
So it would have been 4. According to you, it should have been 2 plus 2, maximum of 4. Had it been 4, your marks would have been 56.18. Right?
Yes, my lord.
Now, what the petitioner, the respondent received? What are the marks?
Our grievance against the respondent number 4 is this, my lord. Against serial number 2, 3, against 2, Roman 3, 4, and 5 of this OM. He has been given awarded marks, my lord, without submitting the documents, my lord. And this is the third round of litigation, my lord.
We have seen that.
And till date, they have not furnished the documents submitted by the respondent number 4 before this honorable court, against whom he was awarded marks, my lord, which is otherwise not entitled to. If those marks were deducted from his record, my lord, then his marks come down to -4. And I will be the.
Yes, thus you have the record with you.
Today, I do not have the record.
If they produce the record, my lord, then entire thing will be clear, my lord.
But affidavit also states only about the marks, distribution of marks regarding respondent.
I'll not let them produce the record, that will clinch the issue.
Mr. Das, come to page 177.
Yes, sir. Yes, sir.
The last paragraph, that's right.
Yes, after the hearing. However, publications of Mrs. So as submitted in the aforesaid hearing are eligible for consideration as the journals was Scopus Index till so. But since he is second author in volume 7, issue 4, she may be awarded 70% marks. And she was third author in the publication in volume 7, issue 6. She may be awarded 30% marks. Total.
Now, what was the order passed? You have the copy of the writ petition?
Yes, madam.
Oh, good. Come to page number 40.
Yes.
Read the first paragraph and second paragraph half, not full. Read the first paragraph.
However, the petitioner is directed to file a detailed representation before the Director of Higher Education Assam, taking all the grounds and also enclosing a copy of the reputation and the affidavit in opposition filed in Procedural, along with the annexures appended thereto. On receipt of the representation, the Director of Higher Education Assam shall hear the petitioner in person as well as the respondent number 3, Principal Siddhartha College, Siddhartha, and the respondent number 4, and thereafter pass final order for appointment of assistant professor in the Department of Assamese in Siddhartha College by taking into consideration the office memorandum dated so as well as office memorandum dated so within a period of 4 weeks from the date of receipt of the representation.
Now you plus come to page number 48. This is a part of her representation which the petitioner filed before the Director of Higher Education in terms of the order of the court.
There are 16 million.
Now, page 48, para 16.
That in respect of Dr. Brojen Sharma, the undersigned begs to state that relevant records will reveal that Dr. Brojen Sharma did not submit supportive materials in respect of research paper, article in the concerned subject, domain published in journal, research book, proceedings volume.
Which ISSN?
Yes. And presentation of research paper in the concerned subject or domain in international, national or regional level seminar or workshop. However, Dr. Brojen Sharma had been awarded total 4 marks against the aforesaid 2 clauses, although he is otherwise not entitled for those marks.
Now, in the order passed by the Director of Higher Education.
Yes, madam.
Because the one OSD was allowed to examine the documents.
Yes, madam.
Right?
Yes, madam.
Here it is written. After the hearing, the publications of the candidates, such and such and such and such, were examined by the OSD of this directorate and found as follows. Here only that portion of the finding of the concerned OSD who examined the documents, particularly the research papers, has been quoted. What about the report relating to the research papers submitted by the respondent number
Brojen Sharma, private respondent, yes, madam.
Before the, because hearing was taken by the director.
Yes,
now, what about this report of the concerned OSD with regard to the research papers of the respondent number 4?
Yes,
Another point subject to correction, my lord. It is not a trial court that the predecessor has recorded the evidence and successor is taking the argument.
No, it
may he had abdicated his authority.
No, that's why you asked Mr. Deka in your absence was whether it was heard by the director.
No, it was not heard. It was done by the OSD.
No, he said that direct, it was heard by the director. Documents were, it is
Final
possible.
order was passed by the director.
No, but if it was also heard by the director and the documents, necessarily director will not go through that extent. We can understand that extent. But there has to be something on the report of the OSD with regard to the documents. There is nothing in this order.
Records will reveal the same. Records will reveal the same. Records whether.
I think the matter is before this honorable court for the last 4 years.
We have
My
seen
lord,
this is
every
not
time they are shy of producing the records.
difficulty is there. Difficulty lies
Records
there.
were called for records, even records were there.
I think they should. And moreover, my lord, on the given date, the respondent Sharma, he was gainfully employed somewhere. In terms of another college, he was already working. And in terms of the Assam government circular, his case cannot be considered within 3 years. And that was also the learned single judge also directed that aspect also should be looked into.
Which college is working?
In Karbi Anglong, one of the colleges.
Was it a direction of the court earlier?
Yes.
And it was the order. Was it a government college or it was a provincialized college?
Provincialized college.
Or a venture college?
If your lordship would kindly come to page 176. On the last middle para, my lord, on receipt of the representation, Director Higher Education Assam shall hear the petitioner in person, as well as respondent number 3, Principal Silapothar College, Silapothar, and the respondent number 4, Brajan Sharma, and thereafter pass a final order for appointment of assistant
that we have
professor.
seen.
And see, by taking into consideration office memorandum dated 8/12/18, as well as office memorandum 25/6/16. And this is the circular which says, my lord, if somebody is employed, then within the next 3 years, he cannot, yes, that we have annexed. my lord.
The private respondent filed any affidavit?
No, man.
No. Lead petition or no?
আমি রিপ্রেজেন্টেশন রাখি দিতে সেখানে
Where is that, Mr. Teka?
Yes,
my lord, I'm charging.
Maybe in the
Type copy.
index you'll find out.
My lord, page 131. Okay, we will work on that copy as well.
After selection to any state government job with effect from 1st of August 2016, employees are not allowed to apply any other state level government job as the in the same position up to maximum period of 3 years. If unknowingly any state government employee do so, his candidature will be cancelled from both posts. So this aspect was also directed to be looked into, but the order does not reflect anything with that. And so far as the petitioner is concerned, my lord, regarding the Scopus mark, in the first interview I submitted, mark was given. In the subsequent interview, neither the original was asked for, nor the marks were given. So that way, my lord, marks which were supposed to given to me was not given, and marks which ought not to have been given to respondent number 4 has been given. So we have shown, my lord, eventually the petitioner should get the first nomination. My lord, at page 18, we have made that statement. Further, in terms of OM dated 25/6/16 towards the middle, selection committee was barred from considering the candidature of respondent number 4 in its meeting dated 16/9/21, as he was already appointed as assistant professor in the Department of Assamese at Government Model College, Dithor in Karbi Anglong on 20/12/20.
Or Mr. K. N. Chaudhary, Assistant Prime Minister, Arun Deka, Consulary and Mr. S. Plus, Understanding Council, are education correspondent numbers 1 and 2. 1 and 2?
One and two, my lord.
Anyone representing the college?
Payang, my lord. Fill up her plate.
Mr. Payang appears for college. What's your good name?
3 and 5. My lord, my friend is appearing for 3 and 5.
What's your good name? On behalf of Mr. J. Payang. Narrate counsel for the respondent number 3 and 5. Respondent number 4 did not appear.
Ardhar is appearing, my lord.
Ardhar. His name shown.
My lord, on earlier occasion, my lord, he appeared, my lord.
Ardhar. The order dated 27/02/2023. Caused by the criminal offence of 14 IA Civil 2044 of 2022. Arising out of application number 7061 of 2021. Arising out in
No,
page 40. Mark will put. Pursuant to the same, the petition on 2803/2002, 2803/2023. Petitioner submits our representation. Deputy Director of Education. Specifying that is entitled. Four marks. As per. This is 4 marks under the heading.
1 second.
What is that, Mr. Deka?
Yeah.
That one, the first one. Just now you had shown me. No? Page 106.
My lord,
106.
106, my dear.
No, 106.
My lord, if it also kindly comes to page 108.
Oh, that's what it is.
Yes.
2, 4.
2, 3, 4.
Right.
Where he has been given, ought not to have been given. And 2, 6, my lord, these 2 marks should have been given to me, to the petitioner. Page 108.
No, you are asking for 2, 4, complete 4 marks.
2, 6, my lord. 2, Roman 6, 2 marks.
I think no, as per the.
At page 108, my lord.
If you come to page 47.
My lord, research paper 2-3 at page 108, research paper article in concerned subject domain, published in journal, research book, proceedings, so and so, etc. This one. And 4, research paper article in the concerned subject domain, published in impact factor journal existing on the date of scopus.
You are seeking full marks in 2, 3 and 2, 4, right?
3 and 4 ought not to have been given to the private respondent, and this Roman 6 should have been given to us.
Full mark in 2, 3, 4. And 2, 6.
2.6. সেইটো মোক দিয়া নাই।
You are entitled for 2
Two
marks.
marks, my lord.
That is the 2 marks, 4 marks, and 2 marks. And also in the said representation with regard to the respondent number 4, the petitioner submitted that the said respondent did not submit supportive materials in respect of research paper of the articles in the content subject public domain published in journal public research book public proceeding volume 14 bracket with ISSN with ISBN public impact factor. Okay. Page 48 of mark 4. There are 6. According to the petitioner, mark 48, there are 6. The selection committee awarded total 4 marks to the respondent number 4 against was awarded marks in 2, 4, 2, 3 and 2, 6.
Yes.
Against 2 within bracket Roman 3.
My lord, at page 25, I have indicated the position ground J, my lord.
Okay, OM bracket 08, 11, 2,
His marks should be actually 64.63, not 68.63.
No, he's not better.
And otherwise I'm getting 66 from 18. So I rank higher. Page 25, my lord, on top.
The speaking order is in stay.
No.
And this influence speaking order is the 2006-203 passed by the director of exam. It is seen that after hearing the matter, the publications of the candidate of the respondent number 4 which have the petition were examined by the officer on special duty of the Directorate of Higher Education and found as follows, page 177. Considering the same, the DHE Assam came to the conclusion the respondent number 4 secured 57.63 during the selection, whereas the petitioner secured 54.18 marks given by the selector. Upholding the selection of the respondent for the post of assistant next. In the state order that the 200620 DHE Assam is silent with regard to the claim of the petitioner has been made. Supportive materials, respect of research papers are taken. In view of the above, the DHE Assam shall place the records in original pertaining to number DHC oblique CE oblique AC oblique N oblique S oblique 414 oblique 2021. Wherein the site director was the speaking order by number একে লিখিবা 2021 common oblique 376 2006 on the next. We will the director to give the record to the next pertaining to list on twenty-fifth. Order to Mr. Actors.
My lord may indicate documents regarding both the candidates, my lord.
Yes, yes.
Documents and-
Entire record will come. The record will have all the documents.
Yes, my lord. Because sometimes what happened, my lord, in records only the documents of selected candidate is there, my lord. Sometimes.
On an earlier occasion, same selection committee has given me that mark.
Item 16 has become infectious to it. Already, regular principal has been appointed.
Lordship, this is the appointment order of regular principal, Lordship. Regular principal is appointed, Lordship.
We challenge the appointment of the private respondent as in charge principal, as the regular principal has already been appointed.
Which is your repetition?
WPC 1941, item 16, my lord.
You are representing the governing body.
My lord.
This in fact has infractions, right?
My lord.
Now, who is appearing for
Item 15, my lord. Item 15, my lord, my friend is challenging the order imposing punishment. That is, my lord, appealable order under Rule 15. Lordship will direct the petitioner to file an appeal before the appropriate authority, my lord, under Rule 15.
No, my lord. May I just submit?
WPC 1941-202.
May I just submit here, my lord?
1941 yes.
1941 I had my lord, may I just
Just a minute. The governing body of Heraz Khat College, Deotola, DEOTOL, Lakhimpur. While they say petition.
Page 95 order of challenge, my lord. Page 95.
Challenging the speaking order dated 30/03/2024. Allowing the who is the principal in charge? Question number 4.
Question number 4, my lord. He was appointed as principal in charge, my lord. That was state.
Allowing the response number 4, the principal in charge of the college to continue the said post of the said college director till it is filled up, till the post of principal is filled up on regular basis. Nikhil. The court violation notice by order dated 05/04/2024 in the interim allowed an assistant professor of St. Catherine's College to function as the principal in charge of the said college in question, said college. To continue to function in the same capacity. No, to continue. Continue. While the response number 4 was placed under suspension and during dependency of the departmental proceeding against her, the person to continue as a allowing the said assistant professor to continue in such capacity until further orders from the court. Observing further that the Director of Higher Education Assam, in the event if it is so felt necessary, may make alternative requirement for holding the charge of the post of principal in the college in question in accordance with the prescribed norms. Heard Mr. Isaacia, counsel appearing for the petitioner, and Mr. Keith will understand the counsel and taking part for the respondent numbers 1 and 2. Mr. Gogoi, understanding counsel ratification. Placed a copy of the order dated 11/09/2023. Issued by the Director of Higher Education Assam before the court. Today, which goes to show that the DHE Assam by the said order dated 11/09/2024 appointed Dr. Mridul Buragohain, the principal of Herazkhat College, on the basis of the recommendation of the selection committee and the governing body, selection committee of said college, as well as the approval of such selection by the governing body of the said college, resolution dated 4/9/2024, and on approval of the state government in the higher education department, white number small e CF number 259349/30 dated 18/12/2023. The Director of Education order number to E 551044/2024/1. Since the regular principal of said Herazkhat College has been appointed by the DHE Assam by the said order 11/09. This petition has become infructuous. My lord, and accordingly dismissed. The interim order passed earlier on 05/04/2024. This stands packeted / record. Copy of the order of the Director of Higher Education Assam dated 11/09/2024 noted every given by the part of the report.
My lord, may I just come in here, my lord? My lord, here, my lord, I was representing respondent number 4. I had filed an IA. My lord, this order which my lord is there, I have challenged this order filing in WPC. because it has taken my increment order and there's been no show. That is another writ petition 2884. So my lord, let me just come in here for a moment, my lord, if my lord allows me. My lord may just check the order of me, my lord may just get through of the IA, my lord, 1811.
Yes.
1811, my lord.
Yes.
Already the petition has been dismissed, my lord.
Oh, let me just.
Yes, yes, Mr. Sharma, what do you want to?
Yes, my lord. My lord, here, my lord, on 5/4/2024, my lord, at para 12. My lord, the said respondent number 4, at the time when the departmental proceedings were initiated against her and prior thereto where she was placed on the suspension, was functioning.
You are reading?
Page 12, my lord.
Yes.
The said reinstatement being, my lord, my lord, 1, 2, 3, 4, 5, 6, 7th line. Being without further specification whether she would be reinstated as principal in charge against a substantial post of assistant professor, a claim may arise from the respondent number 4 requiring the college authority to reinstate her as the principal in charge of the college. Accordingly, the present proceeding had been instituted by the college authorities. This was the observation of the court that there is no particular direction that whether I should be continued as principal or not. My lord, the order, my lord, at page 95 of the writ petition, my lord. At the bottom, my lord.
Yes.
At the bottom. Further, she is hereby reinstated with immediate effect. Thereafter, my lord, whereas regarding recovery of excess remuneration paid to the teaching and non-teaching staff of the college, after reinstatement as principal in charge, she would take necessary steps to initiate recovery and accordingly submit a report to this office on the action taken by her. So that means, therefore, in exercise of the power, before that, my increment was withheld for promotion. I hereby impose Dr. Kalpana Goswami, the charge officer, of withholding 2 increment with cumulative effect. And thereafter, she is hereby reinstated with immediate effect. Now, thereafter, whereas regarding the recovery of excess remuneration paid to the teaching and non-teaching staff of the college, after reinstatement as principal in charge, she would take necessary steps to initiate recovery and accordingly submit a report to this office on the action taken by her. Thereafter, moreover, the college authority will take steps of appointment of permanent principal in Khajirat College after model which is enforced is lifted. So now they have taken it, my lord. Now they have taken the principal. But my issue with this disciplinary proceedings and with the penalty that has been imposed, that I have challenged in 2884.
That's right.
So, my lord,
that petition is still pending.
Yes, that will be still pending. So, my lord, my kind observation that may be reflected in the order is this, that because in this order, they say the selected candidate will join 15 days of receipt of this order. At the bottom, my lord, 11/9/2024, the order which has been placed before my lord. The selected candidate will join 15 days of receipt of this order. So, until his joining is complete, I should be the principal in charge. That is what the speaking order says. Obviously, my right goes off anyway. But someone has to be the principal in charge.
My lord, already a different person has been appointed as in-charge principal. That order was.
Can you name the person, because in the order it is 5/4/2024, the name of that person concerned is not there. Can you tell us who is the person?
Chandan Soikia. He was working as in-charge principal. That order was not, my lord, recalled.
My lord, that order had been passed.
Just a minute. Just
in the, my lord, additional affidavit, I have brought on record everything, my lord.
Who is in which department?
My lord.
Chandan Soikia is in which department?
He is, my lord, well, at page 129, my lord, 129 of the petition, that is the additional affidavit, my lord. Chandan Soikia was appointed as in-charge principal, my lord, on 9/6/2023.
Chandan Kumar Soikia.
My lord.
This is before the fire impugn order.
Senior most.
Thereafter also, my lord,
College.
on page 139, 139, and my lord, 144. 144, my lord, the order says that till the regular principal is appointed, he was allowed to hold the charge. That order has never been recalled. That order is not under challenge.
My lord, may I read the top line, my lord, if may, in order, court's order. It was due to the court's order, which was
Page-
taken,
page 144,
ex parte.
Page 144, my lord.
Assistant Professor, Department of Sociology.
Page 144, my lord. This order is not under challenge, and he is not before the lordship.
Appointed as principal in charge of such and such college by order dated 09/06/2003, issued by the DHE Assam. By memo number DHE of CE of MISA of 28 of 2018/223. Followed by the order of the DHE, the number PC of HE of PROB, P capital of DDO of 02 of 2019 of 917, dated 29/07/2023, as well as the order of the Director of Education Assam under number E.502772 of 2024 of 2, dated 09/08/24 2024, shall continue to remain as the principal in charge of the site such and such college till the zoning of the regular principal till the zoning of Dr. Middle Kukagohai, regular principal appointed on 11/09/2024. On joining of said Dr. Middle Kukagohai as a regular principal of Karaskat College, pursuant to the order dated such and such, issued by the DHE Assam, said Sri Sandan Kumar Saikia, Assistant Professor, Department of Sociology of Karaskat College, serving as the principal in charge of the same college, shall hand over the charge.
My lord, may I just come in here, my lord? My lord, this principal in charge order that the petitioner has got, my lord, that was where my IA was filed for, my lord. My lord, may just look at the order on what basis?
In view of the appointment of regular principal by the DHE Assam on such and such date. And also in view of the read petition filed by the applicant being WPC number 2884 of 2024. This interrogatory application being interest of
My lord has dismissed my read petition also.
No, tell us in the your read petition.
My lord, may.
What happened in the? Yes, who is appearing in the matter? What is your prayer here, Mr. Sharma?
My lord, here my prayer is that my lord, the entire process was conducted without serving me Stroker's notice under Rule 9. My lord, and that is why the Honorable Court was pleased to issue notice, my lord. The Rule 15 would not apply here, my lord, because it is not an appealable order, my lord.
My lord, may at page 44, annexure 9, there is no charges being framed. There is no charge being framed. There is no charge. No, not even statement of allegations. This without any charge being framed, without any whatever we charge about, the show cause notice was served upon me. And therefore, the report of inquiry. My lord, the affidavit has yet to be filed with the government in this, my lord. My lord, there is no statement of allegation, there is no charge sheet, there is no list of documents, nothing was given to me. My lord may see annexure 3, which says the line is at page 32.
The Google, who is appearing? Mr. Upamanu, you are appearing? You have not filed the search, you have not filed the affidavit.
Lordship, otherwise, Lordship, it's an appealable order, Lordship, under Rule 15, Lordship, of the Assam Service Discipline Rules, Lordship.
To that extent, you file your affidavit.
My lord.
To that extent, you file your affidavit.
Yes.
That if you want to saying that this, it is appealable order.
Yes.
Under section 15, you look into that.
My lord, at item number 16, my lord, where the order, my lord, has passed. My lord, my lord should praise this fact that the petitioner who has been, the governing body has filed the writ petition challenging a DHE order, where the DHE order had explicitly given me the principal in charge.
That matter has become infructuous. Okay.
So, my lord, even though, my lord,
Mr. S.P. Sharma, Council appearing.
I appear for the respond of formal.
Mr. T. Upamanu. And the council had a deputation for the respondent was on go and quick. Mr. I had Sakiel and a council for the respondent of 4. Such service of the basis for the respondent of 4. The respondent number, the official respondents number 103. As well as the respondent of 4. Shall file their respective affidavits in the matter on or before 25/09, not 25, 27/09 of 2024. Serving a copy on the council for the petitioners and other respondents. Placed on 1st of October.
Please, Lordship.
Records.
Records I have received, Lordship, but today morning I have received the records.
Mr. C. Sharma, Standing Council, NC Hills Autonomous Council submitted. That in pursuance to the order dated 10/09/2024, he received the relevant records this morning and it to go to the same. Staff has suspended for some time. It's not a good prayer allowed. List on 19th.
Okay, can it be 24? As per suggestion from my senior.
24.
May it please the Lordship. In this case, Lordship, petitioner applied for mutual transfer, Lordship, on online portal, and thereafter she requested not to transfer her, Lordship. But in spite of that, a mutual transfer order was passed by the authority, and accordingly, the respondent number 7 has come to my place, Lordship. And thereafter, while issuing notice, an order was passed that my representation may be considered, disposed of my representation, and at the time of disposing the representation, another order was passed, Lordship. So I have filed one contempt petition and the subsequent writ petition or second writ petition. And thereafter, Lordship, after filing of the second writ petition, after issuing notice in contempt and second writ petition, and DP was initiated, Lordship. Shokos was served to the petitioner.
Yes, Mr. Bora.
My lord, here, my lord, petitioner has filed an representation that has already been disposed of, my lord. She has initially applied for mutual transfer, my lord. My lord. Thomas, sir. My lord, kindly see the speaking order, my lord. Conclusion, my lord. Taking all the aspects into consideration, the plea of the petitioner should be rejected since teacher apply for mutually transfer on mutual consent of each other, and that consent of both the teachers are involved in it. On the other hand, it is reported that by the DEO concerned that the other teacher has already taken release from her school and has joined in the school of the petitioner. As such, the petitioner of this case is without any post which make her ineligible for any salary. What is more important is that the order dated 1/11/2023 was issued from the office of the Director Elementary Education Assam, making it compulsory for all the mutual transferred teachers to take release and to join as per the
It will be listed on 17th. These matters will be listed on 17th.
Lordship, 17, I have some problem, Lordship, but on 19.
19th.
Lordship, item number 18 has been complied with. It can be closed, Lordship.
Friday law.
Lordship, my learned pen has.
Yes, Mr. U. Sharma.
My lord.
Lordship.
My lord, order has been issued by the director here, my lord.
39, can it be on 20, Lordship?
Make it separate. 19, 20 it is, okay, on 20th.
20 is a Friday, Lordship. I'm deeply obliged, Lordship.
Order.
I think not Mr. S.K. Das, counsel is ready for the petitioner, and Mr. U. Sharma, and the counsel.
Sole respondent, my lord.
Or the sole respondent. During pendency of this contempt petition, the Director of Secondary Education Assam the petitioner in the Director of Secondary Education Assam by order dated 11/09/2024 by number E dash 453/405/2024/287 appointed the petitioner as the regular principal. Appointed the petitioner as the principal on regular basis and posted her at Colonel Lakshmi Higher Secondary School, District Kachar. Mr. Das, counsel appearing for for the petitioner, since the grievance of the petitioner has been complied with. He is not insisting on this. The petitioner is not insisting on this contempt petition. According to this contempt petition being in doctor stands dismissed. The order, the notice issued on the sole contempt on 24/06/2024 be recalled.
My lord, in chapter 44 to 46, this person, my lord, is without any salary from 1/4/2022. So may pay for a fixed date, my lord. There's some urgent from that.
25th.
My lord, only 17, my lord. This 19, my lord, maybe fixed. Fixed it.
26 date দিব নেকি?
By the 25th.